timely. It should build the capacity of our project.
Welcome all of you to the inaugural Gumzo La ADR Conference. Today, my Lord Chief Justice, we begin a journey of 5 days dedicated to nothing but to reimagining and positioning ADR as the preferred dispute resolution mechanism for Africa.
My Lord, CJ, you recall during your tenure as principal judge, you together with the Honorable Justice Owiny-Dollo, drawing from the recommendations of the Justice Butera Committee report on case backlog, agreed to implement one of the key recommendations in that report. And the key recommendation was re-engineering ADR. And indeed, as principal judge at the time, followed this recommendation to where we are today.
This conference actually comes at a particularly meaningful moment for Sweden's work in Uganda. Last week, we celebrated the official launch of Phase 2 of our community justice program. Present today. Through the program's first phase, Sweden has supported several key alternative dispute resolution mechanisms. These include the advancement of plea bargaining, the strengthening of community mediation, and the use of the small claims procedure within the courts.
Today, we are now increasing the alignment. What I'm talking about is that everything starts with a nucleus. And once that nucleus, or what you call the core, now we need to expand it. And that is why we have this Gumzo. This is an extremely ambitious initiative. Now, as we leave at the end of the week, let us all become step-down transformers. When we speak of ADR, some people think it is a very complex thing. So let us simplify it the way a transformer steps down a high voltage current to a level that it can be used even for charging a telephone and at the same time for running a factory.
ADR has been identified as an effective strategy for managing caseload and reducing case backlog. Colleagues, you know that actually courts don't resolve disputes, they just decide cases. Disputes are resolved by ADR. That's why even after you have handed over a judgment, someone will want to appeal, meaning that although you have handed over a judgment, someone is not satisfied. The dispute has not been resolved. But how many people appeal ADR decisions? No one, because you have resolved the dispute. You have not decided the case.
We need to market ADR to government of resolving disputes. But we now need to walk the talk. It's a new thing. We've been used to the adversarial system. Marketing ADR will therefore require a strategic shift towards ADR by convincing government that ADR reduces litigation costs. Government spends a lot of money on litigation.
What we need to do is to allow the parties, every time they are in the courts and they get a better understanding of their disputes, a better understanding of the rules, the laws, the facts as they go through the court system, to reevaluate a possibility of negotiating again. In other words, this story that we have done negotiation and it failed, so we must move forward with litigation, has now been debunked. Continuously talk until a resolution is obtained.
We are getting applications for mediation from very senior firms, from the Attorney General, from the banks, from the URA, and a number of other common litigants in that court. So I think let's emphasize training. It will do miracles.
So let me say on behalf of the organizers to thank you for being part of the first inaugural mediation Gumzo. Thank you so much.
It's now my distinct pleasure and honor to declare the Alternative Justice Systems Capacity Building Workshop officially open.
We must respect other places where disputes are also decided. But not only respect, but we must bring them to the table and have a conversation with them. And the AJS is precisely about facilitating that conversation. It is about empowering the other key justice actors, and the training today is about telling you what the justice system is all about.
If AJS was not working, the judiciary would be having 1,670,000 cases. But what AJS has done, it has taken 90% of that. And that is why we have 10%, which is 167,000 cases. So it is important that this conversation is considered seriously.
ADR is a solar system. At the center is the Judiciary of Uganda. So it is like the sun. So the leadership of ADR through this AJS is firmly in the institution of the courts and in the hands of judicial officers.
Alternative justice systems are not mere alternatives. They are the foundation of societal harmony. They are systems rooted in indigenous traditions, cultural norms, and communal values, and encompasses mechanisms like the elders' councils, clan-based reconciliations, and religious arbitration that have resolved disputes for generations. We must evolve these systems to ensure they complement rather than compete with our formal judicial practices.
Let people know the beauty of ADR. Let it be people to come and say, okay, he has brought this matter to court. We have not tried with our community leaders. Let it come. You know, the moment we can reach that stage, then we have hit it. I ask judicial officers, urge the parties, educate the parties, tell them the beauty of a negotiated or mediated settlement. Tell them, please go and try before we hear.
Community justice, as we have seen, the evidence we have gathered shows us every day that community justice prioritizes the outcome and promoting social threat. And this process then definitely ends up serving the demands of justice and ensures that it has responded to the issues that are raised by the different community members.
What I see from the decision, it clarifies that traditional justice mechanisms cannot replace or hold formal criminal trials, but they can be the framework for either plea bargaining or ensuring that satisfactory
We are starting a little bit late, but that's because of the morning meeting that we had. We apologize and would like to thank you for your patience and for your willingness to continue participating in this forum where we hope to get knowledge, experience, and gain networks. Now, today's session is specifically on how to build arbitration in Africa And with us, we have a very esteemed speaker, one of my former mentors and former bosses, Professor Githu Muigai, Senior Counsel, Chartered Arbitrator, who is a proficient and a highly regarded arbitrator based in Nairobi. He also holds a Bachelor of Laws degree and a PhD from the University of Nairobi and an LLM from the Columbia University Law School with a diploma from the Kenya School of Law. He is a former Attorney General and a member of the Permanent Court of Arbitration. He's also a designate to the International Center for Settlement of Investment Disputes, ICSID, within the panel of arbitrators and conciliators. Currently, he is the Vice President of the London Court of International Arbitration Africa Users Council. Professor Muigai is also a member of the International Chamber of Commerce, the Africa Arbitration Association, Kigali International Arbitration Center, and the Nairobi Center for International Arbitration, which he also supports to set up amongst other institutions around the globe. Now, Professor Muigai, as you know, has over 35 years of experience in handling arbitral proceedings domestically, regionally, and internationally. And pursuant to, and he's really well-versed with the different arbitration rules that have been developed in the different arbitration centers and international regimes, which include but are not limited to the PCA rules, the ICSID rules, the ICCU rules, the UNCITRAL rules, LCI rules, the Chartered Institute of Arbitrators rules, and most importantly, the Nairobi Center for International Arbitration rules, for which he pioneered its operationalization. Now, on numerous occasions, Professor Muigai has been appointed as either the president of an arbitral tribunal or sitting as a sole arbitrator in the different arbitral proceedings, and he continues to be retained as counsel for either the disputing party in international arbitral proceedings, including as counsel for different governments. Over the years, Professor Muigai has been commended for his exceptional and intensive knowledge by institutions, parties, and councils. He was most recently recognized by the Lawyer Africa as Kenya's leading arbitrator. Now, this is not the only accolade he has. He has several, and if I was to continue reading, I believe I would take up his time for the discussions. So please join your hands and join me in welcoming Professor Githu Muigai. Prof, welcome.
Thank you. I hope you can hear me.
Yes, Prof, we can hear you very clearly.
Can you hear me?
Prof, we can hear you. Please proceed.
Thank you very much. The Honorable the Chief Justice and Justices present, distinguished members of the bench, the Honorable Ministers of Justice, fellow ADR practitioners from across the continent, colleagues from the academy, civil society and the private sector, and the people of Uganda, our gracious hosts. I have a very special connection with Uganda. I was educated by Ugandan teachers who had come to Kenya after the very unhappy events of the early 1970s, and I will forever be grateful for that. Gumzo in Swahili means conversation, dialogue, the kind of frank, purposeful exchange that builds bridges across difference. It is no accident that the architects of this forum chose that word, because what Africa needs urgently and unapologetically is a new conversation about justice. Not justice as a foreign concept borrowed and transplanted, but justice that is African in character, African in access, and African in aspiration. We gather in Kampala, the Pearl of Africa, at a moment of profound continental possibility. Africa is young, Africa is growing, Africa is building, and Africa is disputing. Because dispute is inevitable companion of enterprise, ambition, and growth. Across the African continent, we are witnessing a period of significant transformation in recent decades. African economies have experienced increased levels of foreign direct investment, cross-border trade, infrastructure development, commercial partnerships involving international actors. These developments have expanded the scale and complexity of economic activity across the continent, with growing investment flows amounting to tens of billions of dollars annually. Commercial relationships inevitably produce disputes that require effective and credible mechanisms for resolution. Foreign investment in Africa surged by 75% to reach an all-time high of $97 billion in 2024. The question before us, ladies and gentlemen, is not whether disputes will arise, they will. The question is who will resolve them, how, and on whose terms. Let me begin with a question. When a dispute between an investor and a government ends in a multi-billion-dollar arbitral award against the state, an award that could have been avoided or resolved far earlier at far less cost, who bears the burden? The citizens of the country, the health budget, the education program, the infrastructure project that does not get built? This, ladies and gentlemen, is not a hypothetical. African governments are among the most frequent respondent parties in investor-state arbitration globally. The costs of poorly managed disputes, not just in financial awards, but in legal fees, in reputational damage, in foregone investment, runs into billions of dollars annually. Consider, ladies and gentlemen, the P&ID case in Nigeria, where a tribunal seated in London awarded a small Irish company over $9 billion against the Federal Republic of Nigeria, a sum eclipsing Nigeria's entire annual health budget. This case arose from a gas processing contract that never produced a single unit of gas. I repeat, never produced a single unit of gas. By 2023, enforcement proceedings were threatening Nigerian state assets across multiple jurisdictions. Dear colleagues, I commend that you find and read this decision. It is an indictment of how we in Africa are failing our citizens. There was error after error after error in the way the Nigerian bureaucracy responded to this case. And that's the center of my contribution this morning. Whatever one's view is of the merits of this case, this case stands as a stark illustration on this continent of what is at stake when a government manages an arbitration dispute without the institutional capacity to respond effectively. The P&ID case did not happen because Nigeria lacked lawyers. It happened because the architecture of governmental engagement with the arbitration, from contract drafting to dispute management, was not fit for purpose, period. That is the problem. Governments are not passive observers of the arbitration landscape. They are active parties. They have an interest in shaping it intelligently. Let's turn our attention for a moment, ladies and gentlemen, to the African Continental Free Trade Area imperative. This has created the largest free trade zone in the world by number of participating nations. An intra-Africa trade grows, so will the volume, complexity, and value of dispute between African parties, between investors and states, between governments themselves. The dispute resolution architecture that Africa builds or fails to build will determine in the next decades whether the FCFTA delivers on its promise. Governments must ask themselves, when disputes arise under the FCFTA, and will they be resolved? Where will they be resolved? Under whose rules will they be resolved? Before which arbitrators? What degree of African ownership or institutional capacity? These are not questions that practitioners like myself alone can answer. They require governmental decision, governmental investment, and governmental will. Let me turn now to the question, or to the issue of the cost of institutional absence. And this is what plagues our republics. Too many African disputes are resolved in London, Paris, Singapore, and Geneva. Not because these seats are inherently superior, but because African parties, including African governments, lack confidence in domestic frameworks. This is a tragedy. Every case resolved outside Africa represents not only revenue loss to African professionals, it represents a statement about the perceived credibility of African institutions. Attorney generals are uniquely positioned to change this by building the institutions, passing the laws, training the practitioners, and demonstrating through the conduct of the state itself that African ADR is worthy of confidence. The foundational act of government leadership in arbitration is legislative. Law is the architecture within which arbitration operates. Within a sound, modern, and consistently enforced legislative framework, even the most capable arbitrators and willing parties are built on sand. What now is the state of play on the African continent as we speak this morning? The legislative picture across Africa remains uneven. Some jurisdictions, Uganda, Kenya, Rwanda, Mauritius, Nigeria, Egypt, have invested meaningfully in modernizing their arbitration legislation, drawing from the UNICITRO model law and adapting it to local realities. Others retain arbitration laws that predate independence and that reflect neither modern commercial practice nor African self-determination. This unevenness is a competitive disadvantage. It is a solvable problem, however. If Attorney Generals treat legislative reform as a priority and not merely as a technically delegated task to the lower ranks of ministries. I turn to the question, ladies and gentlemen, of what must modern arbitration legislation accomplish? Drawing from best practices across the continent and globally, I propose the sound arbitration legislation must achieve the following 5 things. 1, alignment with international standards, particularly the UNICITRO model law and the New York Convention. These are now ratified by 46 African states. This alignment reduces friction, enhances enforceability, and signals to investors that the jurisdiction is a serious player. Number 2, clear judicial support. Courts must be empowered to enforce arbitral awards with speed and finality, to grant interim measures, and to refer parties to arbitration where agreement exists. Judicial hostility to arbitration is often a product of poorly drafted legislation and inadequately trained judges, and not inherent institutional resistance. In Kenya, during my experience in the last 30 years, we've come a long way in aligning the judiciary to arbitration, in persuading the judiciary that arbitrators are not an alternative forum for judicial authority, they are in support of the judicial function. Number 3, clarity on arbitrability. The question of which disputes may be arbitrated must be answered with clarity. Ambiguity chills investment. Government should be deliberate in defining the scope of arbitrable matters, including in sectors of strategic national importance. 4, provisions for emergency arbitration and technology. Modern commerce cannot wait for slow processes. Legislation must recognize e-arbitration, virtual hearings, electronic signatures, and digital awards as valid instruments of dispute resolution. 5, we must have periodic review of mechanisms. Arbitration law is not a once and done exercise. Governments must build in structured review process informed by practitioner feedback and informed by the evolution of international standards. What is the role of the Attorney General or the Ministry of Justice or both? In most African jurisdictions, the Attorney General is the principal legal advisor to the government and the custodian of the legislative program of government. This means the Attorney General is in practice the most important individual in determining whether arbitration law reform happens, how it happens, and how quickly. There are several areas where Attorney Generals can make particularly significant contributions, such as legislative reform, strengthening judicial capacity, and supporting domestic arbitration institutions. Notably, efforts have been witnessed across various African countries in recent times. In Kenya, the Office of the Attorney General and the National Construction Authority have launched public consultation in 2025 on the Dispute Resolution Bill, the Construction Arbitration Bill, and the Arbitration Amendment Bill. All these bills seek input to update the 1995 Arbitration Act, with features like emergency arbitration and third-party funding. In Ghana, the Attorney General has proposed amending the State into brackets Property and Contracts Act 1960 to designate Ghana as the default arbitration seat in government contracts, promoting local hearings at the Ghana ADR Center. In Malawi, the Attorney General has advocated legislative reforms at the Lusaka Arbitration Week 2025, including gaps in the Public-Private Partnership Act to mandate African arbitrations and stronger regulations against fraud. Let me speak very plainly, ladies and gentlemen, about investor-state arbitration, because it is in this area where the relationship between governments and arbitration is most fraught, most consequential, and most in need of honest recalibration. What is the current reality in this area? African governments are disproportionately respondents in investor-state arbitration. The reasons are complex, but they include poorly negotiated investor treaties, inadequate legal capacity in government negotiating teams, regulatory measures taken without adequate legal advice on treaty implication, and in some cases, genuine overreach by both investors and states. The cost is substantial. International arbitration proceedings are extraordinarily expensive. Legal fees, arbitrator fees, institutional costs, and the cost of senior government officials' time. And when the word...
Prof, apologies. Don't want to cut you off, but we lost you. Hello? We seem to have a challenge with the connection. Technical team, some support, please. Can you send a text? We seem to have lost him. Prof, can you hear us? This is very unfortunate. April, can we call Wanjiku and just tell him we lost Prof? Our connection doesn't seem to be aligned. Prof? Oh no. My sincere apologies. We seem to have a disconnect, and unfortunately the contact, I think he has switched off his phone for this presentation, so we are unable to reach him. He's trying to see if we can get the personal assistant. Okay. Hello? Prof? Professor, I don't know if you can hear us. Hello? Brilliant. So Prof has been notified. We are just waiting to try out the connection. But maybe as we try to figure that out, we could pick out some of the reactions from the participants as we wait to see, as we wait to hear if we'll be able to get him to reconnect. So I'm told we are trying to get him back, but before he comes back, we could get initial reactions from the room. Do you have microphones to take round? From the initial statement that we've just had from Professor Muigai, the former Attorney General for Kenya, on Africanization of arbitration processes and the need for Africa to take up its role or its position, given that majority of the disputes are likely to come from Africa. How do we ensure that our legal systems are sound, our legal practitioners are ready, and we have institutions that are able to manage and administer the disputes that are coming from Africa? Thank you, Nanza.
Good morning. My name is Nanza from the ADR Center. And Barbara, this is going to be to you. Sorry to put you on the spot, but because I know you have the answer. One of the resounding downsides of arbitration is cost, especially on the continent. From your experience, especially in the spaces where, for example, Kenya is 40 years ahead of us, please speak to us about third-party funding. Any reforms, any practical considerations for us as we set out, any cautionary tales from your journey as those that have gone ahead of us in this regard? Thank you.
Thank you, Nanza. There was a second question as I think about the response there. There's a second question from this gentleman. Please do flag me once we have Prof back online.
Thank you so much. This being Kuzungumiza, I want to raise the question of removing the arbitral clause in all government contracts. This is something which I heard yesterday. Can someone comment about it? How far are we going? What are the reasons? What options do we have? Are we going to replace it with mediation clauses because all along I was wondering why we don't have a clause talking about mediation, but in all cases about arbitration. What is the impact of this?
Technical team, I don't know what's happening today with our mics. I hope they're not tired. So the question about the removal of arbitration clauses from government contracts, I don't know who made that statement, so I'm unable to react to it. Sorry? Anyone who knows who made the statement, maybe we can get them to elaborate. Yes, Moses.
The president of UNAPSEC, in her remarks yesterday, indicated that the Attorney General and I think members of the executive, there was an intimation that there was no longer a lot of favor for resolution of disputes like that in government contracts. I think that's where that sentiment is coming from. Thank you.
Okay. Okay, so I think that's a question perhaps we need to engage with the government agencies to see how or why they are proceeding with that, because it could be the different experiences that they have had, and one of them could be costs, as raised by Mariam, because even the professor himself has mentioned that costs are prohibitive in arbitral proceedings. But this goes to a question of, and allow me to use my experience here, planning. When you're drafting a contract, it's very important that you're able to identify the most suitable dispute resolution mechanism for the likely disputes that are, for the disputes that are likely to arise from that contract. Why do I say this? When we were in the Office of the Attorney General, he facilitated a dialogue between the litigators as a team that was supporting the litigation of government cases and the government transactions department and the treaties department. Why was this necessary? You will realize, and this is replicated in very many law firms and unfortunately in very many businesses, the people who draft the contracts do not sit with the people who defend the cases that arise out of the contracts in court or in the different dispute resolution mechanisms. Now, what happens is a mismatch in either the selection of the dispute resolution model or in the preference of how a dispute is managed. Now, coming from a legal practice that has now taught us to be dispute managers or contract administrators, what this means is that we must make deliberate efforts to be present in the contract administration process. What does this mean? It means if I am engaging, for example, in a construction, not a construction, an infrastructure development that has a design, build, maybe handover element to it. It means that in the development of that contract process, you bring in all the stakeholders to understand how this contract would be, what are the likely risks, and you build in measures either in the contract or internally to handle any dispute that may arise. So you de-escalate as fast as possible. When you de-escalate as fast as possible, it is easier to manage the contract and it is easy to manage the disputes that would then get to either adjudication or to the dispute boards, or in this case, arbitration or the courts, because you have been laying a foundation of trying to manage the issues. And you will realize that unfortunately for many of the contracts that we get to see, there is always, it's a clause that really, even though it is a midnight clause, surely some thinking must go into it. We know, we call them boilerplate clauses. We cut, we paste, and we assume it will work. So most of our contracts, when you look at them, they say, if a dispute arises, it shall be resolved by amicable settlement between the two contracting parties. What does that mean? If a dispute has arisen, then we settle by amicable settlement, or we say it shall be mediated or negotiated by the two parties. If we are already having a dispute, we don't want to sit together, maybe, or we have let it fester so much that by the time you're bringing us to the table, we are unable to address each other. So the dispute escalates. But if we were clear in how we define the dispute clause, for example, by saying disputes of this nature should be mediated by, be particular about the individual. And in this case, do not mention the person, but maybe the position. So hopefully someone, and from the discussion with the bankers today, this must be someone who has authority to settle. We should avoid putting in dispute resolution clauses that involve people who are unable to resolve those disputes when they are called to the table. And in addition, oh great, we get the clear. Prof, good to see you back. I will take up the question and continue with my answers. But Prof, we lost you when you were talking about the costs, sorry, not the cost of it, but the expense. Actually, it was the cost. So you had just mentioned the current status of arbitration and African governments as respondents, and then you had gone ahead to start talking about how, or rather why ISDS is expensive for several African states. So if we could pick up from there, we'll be very grateful, and welcome back.
Thank you, and I apologize profusely. Kenya prides itself in being this letdown. I apologize for it. I was talking about, ladies and gentlemen, how we capacitate the office of the Attorney General. Across African countries that I have visited,
at this rate, the internet service provider is not keen on us listening to the wise words of the Prof. April, we are reaching out to Prof and his team. Okay.
treats into
Prof, can you hear us? Okay. I am in a dilemma. Do I continue with my monologue? Oh, great. I guess that was an answer. So, unfortunate for you. Okay, so the monologue continues.
of the Attorney General.
Prof.
11. Can you hear me?
Yes, now we can hear you, but we lost you as soon as you began speaking about what Kenya did. So if you could just take it up from there.
Very quickly, because
okay.
I'm having technology issues. When I arrived at the office of the Attorney General in 2011,
we can't have lost him again. Okay. I think he's about to tell us about how he set up the international, what was it called? International Legal Affairs Department that then worked very closely with.
Told them, and then they would say, you know, handle this
Prof.
on our behalf.
Prof.
Yes, please.
I'm really sorry to interrupt you, but can you take us back to 2011?
Okay. When I arrived at the office of the Attorney General in 2011, they said that my video had been disabled by the host. So I will continue speaking without the video.
We can hear you loud and clear. Please proceed.
So I found a system where Kenya would receive international arbitration papers, then the office would instruct a lawyer in Paris or London or New York or Geneva. It was a conveyor belt movement. There was very little oversight. I changed that system. First, I demanded that first we would set up an internal team in the Attorney General's office. Competent local government lawyers. Then we would incorporate a Kenyan law firm with capacity. Then the Kenyan law firm would invite a barrister or a solicitor or whatever to guide us through the domestic law of the seat of arbitration. That was a turning point. We were no longer hostage to a foreign legal clique of legal practitioners who would tell us what to do, how to do it. We owned our case, we owned its difficulties, we owned the evidence, we mined it from the ministries. And I can tell you, ladies and gentlemen, and I invite you to research this point because it's all on the internet, the fortunes of Kenya changed forever. We ceased becoming a victim and we went against the robber barons. They lost case after case after case, and they decided Kenya was not a good victim. A year ago, we were in London. This time I was in private practice. I was representing the government of Kenya. We were co-sued with the government of Uganda on the Kenya-Uganda Railway. The outcome of that case is a matter of public knowledge. I invite my colleagues to Google the case and to Google the outcome. We deployed domestic capacity. That is the only way to get this right, to deploy domestic capacity. An elite team in the Attorney General's office, supported by good lawyers in the private sector and supported by a barrister or a solicitor who knows the domestic system. That system works. What I would discourage with all my might is a system where we create a conveyor belt. We have never read the file. We have never read the dispute. We have never looked at the evidence. We are sued. We send the file to London or to New York, and then we pack our bags to go and attend the arbitration and to do some shopping. It is a very, very bad exhibition of who we are in Africa and how seriously we take our cases. There is a different phenomena that I have seen sitting as an arbitrator in ICSID and elsewhere. You find a country that says, we will not use external counsel. And you find them using internal state counsels. Not a bad idea. But you find that these internal state counsels have not been trained. They have not been prepared by this level for this level of international litigation and arbitration. And then you find an embarrassingly low caliber representation. We don't want either of that. We don't want either we have foreign firms or we have domestic lawyers who are not able to rise to the occasion because they are not even trained for that purpose. So this, ladies and gentlemen, I think is an area that the Attorney General can help to turn the tide by creating special domestic units inside the Attorney General's chambers, identifying a number of domestic law firms practicing at the highest level of dispute resolution, and then coordinating among them. I think we also need to build African forums. I am particularly impressed by the proposed African Court on International Trade and Investment, which represents an ambitious continental vision. And I think we can do regional investment courts. And I think this is a way of taking dispute resolution out of the hands of foreigners and back into the hands of Africans. I have a good example in Ghana. The Attorney General in 2024 amended, as I mentioned earlier, the State Property and Contracts Act of 1960 and recommended that all contracts involving the Ghanaian government designate Ghana as the default location for arbitration. This approach, he argued, would not only reduce the expense and logistics associated with international arbitration, but would also integrate arbitration under Ghanaian legal oversight. The proposed changes would require arbitration cases concerning the Ghana state to be heard at the newly inaugurated Ghana Alternative Dispute Resolution Center, thereby reducing the nation's dependence on foreign arbitration institutions. That's a lesson for us all. Finally, let me ask you, all of us in this room, let me ask you, what are our commitments to action after this whole week of deliberations? What shall we do in the next 12 months? I propose as follows, ladies and gentlemen. Number one, we audit our arbitration legislation. That's the beginning. We audit our arbitration legislation, identify the gaps relative to the UNICITRO model law, commission a legislative reform process with clear timeline and public accountability. Two, establish, excuse me 1 minute.
Prof, we can hear you. Prof, we are listening. We are on number two. Establish.
Two, establish or strengthen an international disputes unit within the Attorney General's office. This, ladies and gentlemen, I advise you from my experience, this is a life-saving step. We will never be able to meet the claims filed against us in an Attorney General's office that has a general civil litigation department. We must have an international dispute settlement unit, properly manned, properly trained. Without that, we are carrying water in a basket. Three, we must review our bilateral investment treaty portfolio. This is very important. We must identify treaties that expose the state to disproportionate liability because they were negotiated at another time when we had less say about it. Now we have more say about it, we should review them. We must begin the process either of renegotiating them or terminating them. South Africa has shown that this can be done, and I think the rest of us should learn from that. Four, we must mandate ADR clauses in all new public procurement contracts above a defined threshold. This way, we will create a pipeline of domestic arbitration practice and normalize ADR. We come from a background, ladies and gentlemen, where investors in our countries approach us on the basis of take it or leave it. I don't think that in 2026, that is the space we are in. We have reached a space where we can tell an investor, this is the dispute settlement mechanism, and you take it or leave it. Five, one of the most unsettling things I discovered in the Attorney General's office when I arrived there in 2011 was that Kenya, and I noted many African governments, continued to submit themselves to tribunals globally in which there were no Africans. There were no Africans, there were no women. I said, how can this be so? How can African disputes be resolved in European capitals by European lawyers, white, old men, without the representations of Africans or women or other minorities? And I said, no. And in all the disputes that were referred to in my time, I insisted that we would have in the panel an African lawyer and preferably an African woman lawyer. These things may appear like they are academic, but they actually do have real practical effect in outcomes and also in the optics that we send to the world. So we don't trust our own dispute resolution mechanisms, so we have sent them to Hong Kong or Paris or New York or London, but we also don't trust any African. Out of 52 African states, we can't trust a single African to be in the panel, and we can't trust a woman. What optics are we sending to the world? Is that we have an inferiority complex. Little wonder that they can now then order 10 billion shilling award in poor African impoverished countries. I do not think that is the right way to go about it. So what should we commit to in the next 5 years? We must invest meaningfully in domestic arbitral institution. And in this one, I have very strong opinion. Kenya has an arbitral tribunal, Uganda has its own, Kigali has its own, Tanzania has its own, Mauritius has its own. I think we are shooting ourselves in the foot. We need one strong collective regional institution. In my opinion, we need one in North Africa, probably in Cairo. We need one strong one in West Africa, probably in Nigeria. We need one strong one in Eastern Africa. And I don't want to be nepotistic, so I will concede probably I would be happy with Kigali, We need a strong one in Southern Africa, probably in Johannesburg. But we must stop this proliferation of African arbitration institutions fighting for the same small market. Yeah? We must develop a national ADR policy that is coherent, cross-ministerial, that addresses access to justice, community-based ADR, etc., etc. We are moving without policy. We must invest in policy, a national ADR policy that cascades the approach from the highest national institutions to domestic ADR institutions. Above all else, ladies and gentlemen,
Did you lose him again? We did? Wow. April, are we looking for him? I think he was just about to give us the last nail on the... Well, this is not a coffin, but... Hello?
we must champion
Prof? Prof? Can you hear us? My test today is to be patient with that particular internet service provider. Prof, can you hear us? Lost? Oh no. Okay. I think in the checklist we have a number of things we've ticked off as Uganda, ADR policy being one of them, so we can smile at least. The room looks very somber. I don't know if it was the delivery of the what to do or how to do it that is making us very reflective. Prof, you're back.
I want to rest my case.
Before you do,
One sentence.
Before you do, just take us back to after the ADR policy, and then you can rest your case.
Okay, I think it's very important for every government to have a coherent cross-ministerial framework that addresses domestic arbitration, international commercial arbitration, investor-state arbitration, MSME access to justice, and community-based ADR in an integrated fashion. Not as a document that sits on a shelf, but as a policy that is budgeted, implemented, and reviewed. Finally, we must champion a regional framework for the mutual recognition of arbitral awards within our region. The fragmentation of African jurisdictions is a genuine barrier to the development of an integrated arbitration market. I am pleased to learn that there was an arbitration done in Kenya, which was then challenged in the High Court of Kenya, and was then referred to the High Court of Uganda. And those three institutions worked seamlessly and came to the same conclusion. That is what we are talking about. We must have a seamless, integrated dispute resolution mechanism within our region. That way we give confidence to investors, we give confidence to the commercial community, and we promote ourselves as genuine centers of the rule of law. I will stop there and apologize again for poor technology on my part. Back over to you, madam.
Thank you, Prof. Another round of applause for the professor for sticking to it, even though the internet connection kept letting us down. I'm not sure if Prof is still there or if we can actually have a meaningful question and answer session. But knowing Professor, I am sure that if we have questions sent to him, he will find ways of giving us the responses. So perhaps just feedback, and if it's a question, we'll try and take it down. We have just 5 minutes before the next panel is to start. So if there's any feedback or question, we will take that and then quickly hand over to the next panel. I know I had a question, so Mariam, I've not forgotten it, about third-party funding. It's still on my list, but Prof is still with us, so questions for Prof, please. Mike, and now we can see you, Prof. Always a pleasure to see you. Where are the mics? We have a question here, a question behind. I would ask us to be quick with our responses. Let's limit it to just the question or just the feedback. Thank you, SC.
Thank you very much. My name is Philip Karugaba. I'm with ENS Advocates. Professor, nice listening to you. I'm curious about Ghana's mandating the arbitration seat with foreign investors in their contracts to be in country. How does this work in the context of an acrimonious dispute with a foreign investor? What confidence can the foreign investor have that they can fly in country, have their dispute resolved and fly out without being leaned on? Thank you, Professor.
Thank you. Assume that,
Professor, we'll just take one other question, then you can give us both responses if you don't mind.
Thank you, Professor, for sharing your wisdom with us. Always amazing listening to you. Prof, you talked about take it or leave it. Recently, the president of Botswana told Trump that if you want diamonds, the buyers come to the sellers. And I personally like that attitude. Now, relating it to this discussion, to what extent does the question of money, financing of projects play in proper negotiation of these contracts, including specifically the issue of the arbitration, where the arbitration should take place? My understanding is that I think most times we lose it because of the bargaining power being weak, because the investor is coming with the money and is dictating terms. How do we go about this to balance the negotiation? Thank you.
Prof, over to you.
I think myself that the tide is changing. It's moving in the opposite direction. I read only last week that Ghana has decreed that it will not sell cocoa, raw cocoa, to Europe. And I think its neighbor is about to follow that. They are 70% producers of world cocoa. Now, it is those who want to buy cocoa and make chocolate who will have to abide by the terms that Ghana has set. I think the tide is turning in Africa, and I think the case you mentioned of Botswana is a clearly good example. In the 60s and 70s, Africa was on the back foot, and both in how governments were managed, and also in terms of the knowledge, the institutional capacity, etc., etc. I think that is changing, it's turning. I see a healthy turning of the tide. We are taking control of our resources. We are taking control of how we manage disputes with those who have invested in our country. I have been involved in about 10 different disputes with the Republic of Kenya, with investors who thought, the majority of them having done absolutely no work, briefcase companies. They thought that you could have a country you could quickly pick on and run off with some dollars. That perception is changing. And I think that speaking for Kenya, because that's the country I know, fewer and fewer countries are picking a fight with us because we have shown them that we can fight back, and we can fight back successfully. And I think that is a lesson that is being learned across the continent. One thing that I cannot stop repeating is the necessity to build domestic capacity, not only in the AG's office, but in private law firms that support the AG's office. Because it makes a whole lot of difference when these claimants, so-called investors, are able to see that you have the resources, you have the domestic resources to find the evidence, to marshal it, to systematically present it, and you have the knowledge to argue international law. Our soft underbelly, ladies and gentlemen, and I will not sugarcoat this at all. 60 years after independence, 95% of African governments are taking their disputes, appointing foreign lawyers in foreign capitals, and then washing their hands off the dispute and waiting to be told its outcome. This is absolutely shameful. I think that the time has come for us to be proactive. We shouldn't be signing first place. We must have the capacity to interrogate what the contract itself is saying and what issues we can be able to raise are unacceptable to our own government. I can tell you from my experience, there are very few government legal advisors who are doing this. It is shameful. We must negotiate. The best arbitration outcome is one that never happens in the first place, because we negotiate a contract and we negotiated properly. We made an input into the contract. We didn't merely sign on the dotted line. That is what I would advise. I have sat in arbitrations where I see an African government struggling to reconstruct their file. The contract was signed 10 years ago. The Ministry of Energy doesn't have its file. The Ministry of Minerals doesn't have its file. The Ministry of Justice doesn't have their file. So they have a general broad defense that is not backed by evidence. That is shameful. We must have a capacity by training and otherwise to build a domestic capability of responding to claims against us. Thank you.
Thank you very much, Prof. I think we will release you, given the fact of time, unless there's a burning question. Okay, I don't see you on fire though. It would be nice you'd at least brighten us up today. Please, the last question to Prof, and then we'll release him.
Thank you. Thank you, Prof, for a good speech and insightful. My name is Patrick Turinawe at ENS. My question is about the proliferation of arbitral institutions. One of the key highlights from your speech is building capacity. And it is also, the institutions are part of the mechanisms of building this arbitration capacity, skilling, understanding how to run these institutions, and also being available to reduce cost on the international arbitral institutions. Wouldn't that contradict, if at all, they are reduced to just the regional institutions? But the other element is maybe what you would think of the situation in Uganda, where one of the national arbitral institutions has been now reduced to a department in government. Thank you.
Prof, over to you. Sorry, Prof. There is a judge with a question, and unfortunately, I cannot say no to her. So the question, the mic, please move it.
My lords, all protocol observed. Thank you very much, Professor. I am Justice Susan Odongo from the Commercial Court of Uganda, division in the High Court. You noted that we, as African states, would need to audit our ADR legislation and consider the gaps in the international instruments, say the ancestral rules. However, the reality on ground is the fact that African states are largely borrowers. They rely a lot on foreign aid, and most of these clauses, say perhaps the boilerplate ADR clauses, are largely inspired by the provisions that have been set under the financing instrument. So in as much as it's important for the African states to align and audit their ADR legislation, or even build capacity, there is that underlying aspect of the lender dictating the principal ADR clause that would trickle down into the various agreements that emanate from the underlying financing agreement. So I don't know, how would you reconcile this, considering that African countries are largely borrowers?
Thank you, Judge. Over to you, Prof, for the two questions.
I'll start with her leadership's question. I think that the bargaining power between Africa and her investors has changed. There was a little conversation earlier about that. I recall years in which most of the contracts would state things like the law of the contract shall be the law of England, the seat of arbitration shall be in London, etc., etc. And I remember the shift coming slowly, where we were able to say the law of the contract shall be the law of Kenya, because the contract is to be performed in Kenya and Uganda or any other country. So that has shifted. And now we are going to an area where we are saying the seat of arbitration shall be a neutral seat. So if this is a Swiss-Kenya contract, you say, okay, let's arbitrate in Mauritius, or let us arbitrate in Kigali, or let us arbitrate in Johannesburg. I think we must keep pushing at the door until a day comes where we say, like the Ghanaians are trying to say, the law is Ghanaian law, the seat of arbitration is Accra, and the procedural law is Ghanaian law. And I think that is something that will happen in our lifetime. Finally is the question about having an arbitration center that is wholly government. The real issue in arbitration is that you want an independent, autonomous arbitration body. So if it is in any way linked to government, very few investors will feel comfortable to be contracting with government, and at the same time, if a dispute arises, you will go to a quasi-government institution. So I don't think, if that has happened in Uganda, it's not a wise move. I think a wise move is to have a truly autonomous body in which both investors and government and other actors can have confidence in. Thank you.
Thank you very much, Prof. A round of applause for Prof. We appreciate you for your time and, as always, for your wisdom that you espouse. And we look forward to the next discussion that we will have with you, and go back to the commitments that you've asked us to look at, the call to action. There were 7, if I was not wrong, and we'll be ticking the box. I think you'd be happy to learn that Uganda already has an ADR policy and is working towards improving its legislative framework that would promote arbitration and other dispute resolution mechanisms. So thank you very much, Prof. Once again, on behalf of the participants, we thank you and karibu sana next time. Hope to see you here in Uganda soon. Asante sana. I'm told there is a gift. I'm told there is a gift for you, and unfortunately for you, they have entrusted me with it. So apparently I am to look for you when I am next in Kenya. I've received it in front of the team so that I can hand it over to you. But thank you. Asante sana, Professor. Thank you for your patience. We will be now moving to the next panel. I do know I have a question from Nanza to answer. Okay, she's insisting I answer it, but we're considerably out of time. So third-party funding is very controversial still in Africa because we have the Champati rules that prohibit anyone from getting a benefit, especially getting into an arrangement for a benefit out of the outcome. South Africa has tried to legislate for it. That is the only country I know in Africa that is pro third-party funding. It helps when you have individuals who are unable to participate in an arbitration forum. But it does raise significant questions over the vexatious or frivolous nature of some of the disputes that are funded, and sometimes how interruptive some of these suits can become when not controlled. But it would be interesting if we were to sit down and look at, for example, why Singapore and Hong Kong, for example, have very deliberate rules on third-party funding. I think just like cryptocurrency, when it came out, majority of the African governments first said it is not currency, it is not recognized as currency. But then we had to backtrack later on and start saying, okay, we are going to recognize it as currency if A, B, C, D, E, F is met. So perhaps a question to the judges, when this comes before you and it is clear that an arbitration was funded through a third-party funder, what kind of jurisprudence are you going to develop for us? And on that note, I'm going to call Justice Patience to introduce our next speaker and take up the next panel before we break for tea. Asanteni sana, webale nyo.
Thank you so much, Barbara. In my language, we say Twakwashira. Welcome, welcome. My lords, your worships, senior counsel present here, distinguished participants, members of the Fourth Estate, good morning to you all. My name is Justice Patience Tumsime Rwagumya. It is a mouthful of names, but I prefer to be called Patience. That is enough. Let me first of all thank the organizers for giving me this opportunity to be the moderator, but also most importantly, to congratulate the organizers of this workshop. You must agree that this has been a world-class conference. We do not have to go to London. We don't have to go to Paris anymore. So, well done and congratulations. I was just teasing my brother, Senior Counsel Gimara, that we no longer have to travel, so where are we going to shop from? But that is a good thing, and that is what the professor was alluding to, because it is about building local capacity. If we're able to, and this is what we've done in the last 4 days, that if we are all on the same page, understanding what arbitration is about, understanding the dynamics and the principles, then we can handle these arbitrations, and we'll save a lot of money, which can then go to handle other areas. So this morning, we are also honored to listen to a distinguished gentleman, a person that we all admire, a person that has made a name for himself. His name actually speaks for itself, so I don't even have to say so much about him, and that is His Lordship, Justice Stephen Muwiro. If you can come and take your place. His Lordship has been serving the High Court for 10 years. He was first deployed in Arua High Court, and then he moved to Gulu, and later he was transferred to the Commercial Division as the head of the division, and he is currently serving as a senior resident judge at the Mukono High Court. Before then, he was a lecturer and the head of the bar course at the LDC. His Lordship is very passionate about arbitration, and you could not have picked a better person to speak about this. This has been seen through his precedents, the judgments that we all read. He has been very clear about party autonomy. I joined the Commercial Division, and he was my first head of division. And I keep telling him that there's no single judgment, if I've written anywhere ruling, where I do not quote him. Because when you read his judgments and his rulings, it is like he's teaching you. So even before you get to a decision, you'll know where he's coming from. It is well structured. It is one of those rulings that each person then, you take your time and you learn something from it. So my Lord, we thank you so much for your dedication, for the excellency and your spirit of teaching us. But also His Lordship has the kind of energy that most of us do not have. When I joined the division, I noticed he sits in court from 9 o'clock to 4 p.m. And I said, who does that? And I said, if this is how we are going to live, I'd better find my way back to Uganda Revenue Authority. And he told me, he counseled me, he said, no, my Lord, each person must find their own way on how you conduct your business. And that is the kind of person that he is. Many of us look to him as a father, but he has taught us, and he has the time and the willingness to be able to mentor all of us. So my Lord, once again, thank you so much. So this morning, he's taking us through the topic, why ethical arbitration is the key driver of successful domestic arbitration. Why is ethics important in arbitration? Does it play a role? Does it enhance the drive towards using ADR as an alternative to litigation? Where does that place us if we are going to have successful arbitration? What we have to consider in terms of making sure that arbitration is trusted, it is a dispute resolution mechanism that the parties will willingly include in their contracts, so that then there is a reduction in the case backlog, but also that we're able to have cases handled in mediation, in arbitration and then trusting that whole process. So without saying so much, my Lord, you are very welcome. Let's put our hands together and welcome His Lordship once again, who will take us through the topic. My Lord, you are very welcome.
Thank you very much, my Lord, for the very kind words of introduction. My Lords, your worships, distinguished participants, I thank you for inviting me to share my thoughts about the importance of ethical arbitration domestically. When I was invited to speak about this, I thought about what drives disputants to choose a specific mode of resolving their dispute. And what came to my mind are possibly three considerations. The first one, in no particular order of importance, is convenience. Parties who are already facing a dispute would like as much as possible not to add to their situation any further burden. So they will look at the most convenient mode of resolving that dispute. And here convenience might be physical, that is access physically, as well as understanding the processes that will be involved in that choice. I thought that the second perhaps could be the cost. Some processes might be prohibitive financially and out of reach for some disputants. And lastly, I thought confidence in the outcome, both the process and the outcome. And to my mind, this is the most important because of the goal. What is the goal of choice of forum or choice of mode? I think the goal is finality. They would like to end the experience of dispute and move on with their lives, to get something that is acceptable as an outcome, resolving that dispute, and thereafter move on. So it's finality. That is why I have as my title, the title to the presentation, Ethics as the Key to Finality. Pardon me for the incorrect date. It is delivered today, not last year. And that was a slip. So in talking about this, excuse me, I think I will need to be assisted in moving the slides. The pointer does not seem to be working. Or am I pointing it in the wrong direction? Okay. I broke it into multiple talking points. First, to look at the nature of ethics. Do you agree that we have a common understanding or workable understanding of ethics? Why is it important for arbitration, especially domestic arbitration? Then I'll flag up some issues of sources. Are these principles found anywhere? Are they codified? What are the sources of these principles domestically? The sources I looked at were mainly from the region, Uganda, Kenya, Rwanda, and a few from South Africa, which I compared with those in the US that have attempted to codify principles relating to domestic arbitrations. And I found some commonality in the principles, which are then broken down. Competence and integrity is one common principle. Impartiality and independence, transparency, fairness and due process, confidentiality, promptness and diligence, how to relate with parties are the ones I found to be common and most prevalent in these different jurisdictions. Then I'll come to the conclusion of the presentation by highlighting the role of ethics when it comes to enforcement of decisions and setting them aside. How does it play out at that stage? And then lastly, where as judges have we found okay. Thank you. So my perspective of ethics for our morning's discussion is that we are talking about moral principles, duties, and standards of conduct of participants in the arbitral process. It is not limited to the arbitrator, but the focus this morning will be on the role of arbitrators rather than the parties and their counsel. One aspect of ethics is that it is not static. You can't have principles that are fixed in time, never to be reviewed. They are not immutable. They are non-immutable. And therefore, they keep on changing. The other aspect of ethics is not universal. If we considered what is ethical in one profession, it may not be acceptable in another profession. That is in professional communities. You may also find domestically what is ethical in one jurisdiction might not be acceptable in another jurisdiction. But common to all, whatever the community we are dealing with, it is a reflection of a collective conscience of that community, be it professional, be it social. Therefore, when you are thinking about or talking about ethics, it is not about what is enforceable by law, but what is acceptable as moral conduct by a given community. Then the enforcement reflects that kind of quality of ethics. Some rules are not written down anywhere, but when they are violated, society will sanction whoever has violated those rules, mainly by ostracizing them. You'll get some sanction of sorts. You are no longer acceptable in the community. There will be a kind of isolation of the individual, and people would not like to interact with you for violating those types of norms. So it is a very amorphous kind of concept, not well defined, but many times understood when it is violated. Why is it important for arbitration? I reflected on my experience at the bar. I had 25 years of practice before I joined the bench. And one thing that I remember about practice, you don't have a choice of judicial officer. Once a case is filed, or you might get instructions after a case is filed, and it is already allocated to a judicial officer. There are occasions when a judicial officer, for whatever reason, chooses to behave in a manner that is unacceptable to you as a practitioner. They are human beings. They have bad days as well. Or we have bad days now that I'm part of them. So you might be a very noble person, but for a particular litigant, compatibility becomes a problem. They either don't understand you or you don't understand them. And the perceptions change between the bench and either the bar or the litigant. Whatever you are doing is perfectly correct according to the procedures, but the perception of the individual is that the application of the law is skewed against them. And sometimes we had misunderstandings, fundamental ones, about interpretations of laws. And the person on the other side is so obstinate, they don't want to listen to your views about your interpretation. It was very frustrating. I remember one case, it was before a grade 2 magistrate, a place called Buwama, along Masaka Road. I used to drive there to defend someone who was accused of criminal trespass, a client. Now, the magistrate could not make the distinction between civil trespass, that is as a tort, and criminal trespass as an offense. One element was lacking, glaringly lacking from the evidence by the prosecution. You can't have constructive possession as the basis of a criminal trespass. It has to be actual possession. The magistrate could not make that distinction. Even when I brought it to his attention, there was no reason to prosecute my client. So the trial went on. He was very diligent during the time for prosecution. When it came to defense, he became very evasive. I would drive, you remember in those days we didn't have mobile phones. So you wouldn't know whether I would be around at the court or he wouldn't. Many times I would go there and he's absent. On occasion I would be told he has just left. So it became very costly for my client to move witnesses on days he was supposed to present his defense. Then the information I got, he was meeting the other parties at a bar in the evenings and they would socialize. So to me, he was not a proper judicial officer to preside. But I trusted, like we used to do whenever you get an obnoxious judicial officer, just get your stuff on the record. This person is not final. There is a right of appeal. Once you have your record proper, it will all be reversed on appeal. So I waited. I knew my client's fate already. He would not survive a conviction, and indeed he was convicted. Now what the magistrate did, he sentenced him to a month's imprisonment. When I checked the MCA, there was no right of appeal when the sentence is 1 month. Now, the behavior of that magistrate can easily be the behavior of an arbitrator. What are the commonalities between that experience of mine and what an arbitrator can do? When you have a decision, an award by an arbitrator, there is no right of appeal, except if it was reserved by the parties. And even when they reserve it, it is limited to points of law, not fact. Whatever they establish as fact is final. Imagine if an arbitrator engages in misconduct that is subtle, not very obvious, but it affects the outcome. It's not on record anywhere, and they are seeking enforcement, the other party is seeking enforcement. What remedy do you have? Where do you complain to an arbitrator who is engaging in misconduct? With judicial officers, there is a forum for complaint. Where do you complain? Who disciplines arbitrators? So ethical conduct is more fundamental in arbitration in comparison to adjudication in courts of law. If a judicial officer engages in misconduct, you have a remedy. If it is on record, you can appeal. If it is off record, but it is supported by evidence, the JSC will intervene to provide relief. Where do you get relief from when an arbitrator misbehaves or engages in misconduct? Who disciplines an arbitrator? Supposing you don't succeed, and it's not very easy to succeed in setting aside an arbitral award as I will be demonstrating shortly. Have you achieved finality in a fair manner? Probably not. So these are some of the questions that arise and emphasize ethics as very fundamental to arbitration. Once the ethical aspect goes, once it is destroyed, confidence in that process is lost. You will not have many people coming to arbitrators to seek their intervention or provide solutions to their challenges. Therefore, ethics lies at the center, at the heart of inspiring confidence in arbitration, more than it does in trials. Second, in courts, we have compulsory jurisdiction. In arbitral processes, it is consensual. You choose your arbitrator. To what extent can you complain when you made your choice? Were you forced to choose that person? Do you take them as they are? Do you have a right to complain? Again, these are issues that may arise. What degree of misconduct would justify a complaint against an arbitrator of your own choice? Can you predict how they will behave? Because when it arises in court, you move court for disqualification or recusal. It is also available in arbitral processes, but what is the trigger? What is the standard that will be applied in those processes? I've already mentioned the absence of clear enforcement mechanisms as one of the, I think, negative aspects of ethics issues in arbitration. But on the other hand, this choice that is made by parties, they are autonomous when they choose to go to arbitration, is driven by the expectation that the process will be just, it will be transparent and credible. That is the motivation. They don't submit to a process that is, from the moment it begins or during its course, is diverted into unethical behavior. They expect a fair award at the end of it. If the process is entirely unfair, as I will demonstrate, the courts will intervene, but the interventions are limited by statute. If you can please help me move the slide. Oh, it has eventually. In Uganda, we don't have a code of ethics which you can refer to as common to arbitral processes, but these principles can be found in multiple sources. It is not an independent, identifiable code. Is there a need for codification, standardization? I would think so, because for the judiciary, we have the Code of Conduct. I think it was of 2013 or thereabout, 2003. Do we need a Code of Conduct? Who has the authority to make one? And to what extent will it be binding? Is it a voluntary accession by different institutions or individual arbitrators? Principles can be found in the Arbitration and Conciliation Act, and I'll be highlighting them when I deal with the individual elements. Parties can, in their agreement or submission to arbitration, include ethical requirements or expectations about the qualities of the arbitrator. That could be the starting point. If you select the arbitrator, what are the qualities that this person should have? It can be included in the submission to arbitration, the clause on that submission. At the time you're agreeing on procedures, they can also be embedded, some of these principles can be embedded in the agreement on procedures at the commencement of the arbitration. If it is under an institution, you could consider the institutional rules. They may not have a separate code. I don't know whether ICAMEC has a separate code. You've designed one? Okay. So you can look at the code for the institution or the rules that are passed by that institution. We have a divide between institutional or arbitrators appointed by institutions. You would expect that the institution has some leverage in calling them to order, in the selection of someone whose integrity is trusted, perhaps sanctioning them when they receive negative reports about the experiences of the disputants and their advocates, and so on and so forth. I expect I'm just posing these questions to invite a sharing of experience. Have you had cases of complaints in the institution from advocates involved in arbitration or the parties themselves? How do you handle these complaints? To what extent or how much authority does an institution have over an arbitrator that is affiliated to that institution? What kind of leverage do you have over them if they choose to disobey or to ignore when the instructions or suggestions, recommendations that are given to them? So these are some of the issues we have for domestic arbitration. The first principle that is important for any arbitrator is competence and integrity. If it is an institutional arbitration, we expect the institution to select persons of proven integrity, proven honesty, who understand the role and duties of arbitration. If it is a private or ad hoc type of arbitration, I think the persons who are doing the selection are guided by the competence and honesty or integrity of the individual they are selecting. The person should be capable of performing their duties with fairness. They must be qualified and capable of upholding the dignity of that office. When we are appointed as judges, we have competencies, basic competencies across all disciplines of law, but we tend to specialize in certain areas and come off as, I think, better equipped in the way we handle or deal with particular areas of the law. Sometimes we struggle in other areas. It's like you're going back to school to relearn the law because you've been so removed from that area of the law for a long time. When you're appointed, you relearn the law all over again over that area. That is expected of arbitrators. You may not be a jack of all trades. You can't be competent in all disciplines, but you should be able to improve on your competencies whenever you are called upon as an arbitrator. That is the expectation. But you should also be honest. Sometimes the time is so limited, you don't have the liberty to upgrade your qualities, your skills before the process begins. You are expected to act honorably and decline. You appreciate the confidence the individuals have in you, but you realize internally, self-assessment, that perhaps you don't have the competencies to deliver a fair and sound award in that particular area. So it's a two-way type of assessment. The institution and parties might assess, but you're also invited to make a self-assessment about competencies. Will you be able to appreciate the law that is involved? The facts that are likely to arise, they may be very complex. Do you have the support you need to navigate all these types of issues when they are placed before you? And under Section 12, subsection 1 of the Act, an arbitrator can be challenged if he or she does not possess qualifications that the parties are looking out for. So if you select an arbitrator, or before you select an arbitrator, I think it is important as an institution to find out from the disputants which qualities are important for the type of person that they need to preside over their dispute. Impartiality and independence is the other quality. It is difficult to find a neutral arbitrator, especially in some types of conflict areas. Construction, you are likely to have an engineer, or an engineer sitting on one of the arbitrators if it is more than one. Is that engineer neutral? Probably not. They have experiences in that field, but they can be impartial. They have no interests in that particular dispute. So it's not about neutrality, it's about impartiality. You might be a member of the profession, very active, but for which case you are not neutral, but you have to be impartial, meaning that you don't have biases or preconceived positions about the conflict. So the arbitrator is expected to take stock of their relationships, their private interests, and see whether there is a possibility of conflict. The test is real apprehension of bias or a real danger of bias. Many times when someone raises these issues, we take them personal and engage in a kind of confrontation. You think they are challenging your ability to be impartial, which it is not. It is not about what you feel, it is about perceptions. What will a reasonable person, well-informed and honest about these circumstances, what will they perceive me to be? Can I be fair from their perspective? So it is the standard, it is an objective standard. It's not about your personal perceptions of how fair you believe you can be. And perhaps I need to emphasize that an arbitrator can be challenged if there are circumstances which are justifiable, which give rise to a justifiable doubt as to his or her impartiality and independence. You don't come up with a claim of partiality that is not substantiated. Some people use it for forum shopping. They just throw it around because they don't like the person presiding and frustrate the process by objecting to every arbitrator that is appointed. Transparency is the other. An arbitrator has to be transparent about any matter within their knowledge that might create the impression that they probably are not impartial, or that they may be biased about one of the, or against or in favor of one of the parties. So when you are approached as an arbitrator, apart from examining your competencies, you also examine potential areas of conflict. It's a legal requirement that this has to be done, but you also find it in some of the codes in the jurisdictions that I've mentioned earlier. It's a personal, I'll share an experience. I think it was yesterday or the other day. A witness came to my court. I last saw him as my teacher in primary 2. No one in the court knew about it. The teacher himself could not remember because I've changed so much. You can imagine a person you last saw in 1974. I don't look the same, so I had to remind him, you are my teacher in primary 2. And I brought it to the attention of the litigants. This is the situation I'm facing. You are not aware of this, but this was my teacher. So should I continue to preside? I was not aware he was coming as a witness until I saw him walk through the door when he was summoned as the next witness. Should I continue with the trial or should I disqualify myself? So I gave them a few minutes to confer with their clients and come back to me. They came back and said, no, I think that was a long time ago. You can as well continue. We have gone too far into this litigation. It would not be cost effective to continue with another judge. You can go on. But I had to put it on record because you never know when this comes up. Right now, when I'm presiding, no one knows about it. But when one of them loses, they can easily find it as a ground for appeal, and it's a correct matter of fact. As to what extent it may influence my decision, they must have an opportunity to make that assessment, whether they believe, despite that type of connection with a witness who is not one of the parties, I'm likely to be biased in favor of the parties. So it can be as demanding as that. Matters which are unknown to anyone, but which, if they arose later, might cause that kind of perception. It is an obligation to raise them, even during the process. And this reminds me of a case that came for setting aside. It involved an advocate who had practiced, I think, for 2 years with a law firm early in his career, gone on with his life, worked in about 10 other different places. Then he was appointed arbitrator. And one of the advocates came from the law firm where I had worked for only 2 years. I think it's about 20 years back, if I remember correctly. Then during the process of arbitration, he wrote a book and dedicated that book to a member of the law firm, a senior member of the law firm. So the question was that ground enough to set aside the award? Was he under an obligation to disclose that he still had affection of that nature for the firm? It was not an easy case for me to decide because I thought there's a lot of time that went into this arbitration. A lot of resources were invested into this process. I can't just set it aside on flimsy grounds just because of perception. So I struggled with that decision. I don't know whether I made the right decision or not up to now, but I had to make one. I don't know whether it was appealed or not, I'm not sure. But it was a difficult decision to make. Finally, I thought, no, this is not proper. If it were me in that position, perhaps I would also feel I've had a bad outcome. If I had known this, I would have objected. So I tried to project myself into the position of a reasonable person who is aware of all these facts. What would they think about the arbitrator? And I don't know whether I applied the test correctly. I stand to be corrected. That is the beauty of being a trial judge. You can make your decisions, and if you are wrong, the higher courts will correct them. I'm looking forward to being corrected if I was wrong, but I had to make a decision. So these are some of the nicer points that are not so obvious, but you'll struggle with as an arbitrator. Is this a matter for disclosure or not? I don't have answers. Each case will be decided as it presents itself to you. Then the other area is fairness and due process. The arbitrator must be able to guide the process fairly, give parties opportunity to present their evidence, test the evidence of the adversary and also present the arguments before you come to a decision. And evaluation also has to be balanced. You consider all matters before and then make a decision. It is important to treat parties equally, inform them of all steps you are taking in the process, no ex parte communications. And charging of fees is also another ethical issue. The first time I encountered arbitration in practice was when a senior member of the law firm I was practicing in was appointed arbitrator. I'd never seen arbitration in practice. I'd learned a few principles about it. So he was arbitrator. I used to attend some of the proceedings just to learn what goes on. At the end of it all, there was a dispute as to who should pay his fees. I think he was doing it for the first time himself. There was never an agreement on fees. So what he did, being an advocate, he filed a bill of costs. And it was taxed. The amount was exorbitant. It was almost half of the award after the taxation. So the gentleman who was entitled to the award appealed the taxation. My senior in the firm could not deliver the award to them. He was holding on to the award. I can't, until I'm paid, you don't have an award, but it's ready. So there was a contest for a long time, very embarrassing to me as an individual, because I thought, how do you get yourself in this situation? You've done your work, now you are struggling over recovery of fees, and it was too embarrassing to continue. But somehow, they settled the matter out of court. Eventually, he delivered the award. But there were ethical issues there. Is it possible now to demand a fee that was never agreed upon at the commencement of the arbitration as an entitlement, or must the fees be agreed upon at the commencement of the hearing? I thought those were some ethical issues that can arise when it comes to the collection of fees and expenses. Confidentiality is the other. Arbitrators must be trusted with a lot of information which they should not share that comes up in their processes without the consent or approval, preferably in writing, coming from the parties. Insist on written consent if there is any information that is to be shared by non-participants. This also includes attendance. Don't permit individuals who are not accepted by the parties to be in attendance. It is a private process attended by only those who must, with the consent of the parties, be present in the processes. Promptness and diligence, we've had some issues here where, due to multiple reasons, the statutory time is exceeded and there is disagreement as to whether there should be an extension of time. You know, when you start an arbitration, you believe strongly in your case. But during the process, you begin to realize probably how weak your position is. And you can now tell what the outcome is likely to be. Now, if the time runs out and the award has not been handed down, what is your incentive to agree to an extension of time? You are likely to frustrate that process. It has happened in a few, I think 2 or 3 cases that came before me, where there was an issue of whether the award is sustainable when it is delivered beyond the statutory time, and the extension is made only by the arbitrator without the participation of the parties. Do you have that power to extend the time? Mandate is given by consent. It is limited by statute. Can it be extended without the participation of the parties? That is an issue that is still to be determined finally. I think we have a few decisions at first instance about those types of situations. So you have to have ability to call the parties to order. They should not waste a lot of time, stick to timelines, enforce them, And perhaps at the beginning of the arbitration, there could be an agreement on how to penalize violations of time. Relationships with other parties is another area. I've touched upon it previously. But respect autonomy of the parties. You can't insist on continuing the arbitration when the parties choose to settle. And you can't force a settlement when the parties are not willing to settle. They are in charge of that process to an extent by virtue of their autonomy. And gifts and other favors coming from parties and council, they should be avoided. I've worked in our country stations. There is a tendency of parties there to believe that a judge should be given a gift after they've made a decision in their favor. In Gulu, someone brought a goat for me. Said, Judge, I think this is something you should take. And he was offended when I said, no, I can't take this. In Mukono, a lady I granted bail insisted on seeing me for a long time, and I was stopping. But when she came to the chamber, she said, my lord, I want to give you a token of appreciation for granting me bail. I was there for 3 years. Many judges had rejected my application, but you allowed it. Please accept some token of appreciation. Now, I wondered, how do you take that as a judge, a token of appreciation by a litigant? So they will approach you in private. I think they sent an emissary. They knew someone, and they said, we want to meet you at home. I said, no, you can't come to my home. So she insisted and came to the court. So these are experiences that we have as people adjudicating. I don't think they are limited to judges or magistrates. I've never been an arbitrator, but they may present themselves to any of you. When it comes to setting aside proceedings, this is another point where ethics becomes critical. There are many grounds for setting aside an award when it comes to court for enforcement or for when it is objected to for purposes of enforcement. You read section 34, subsection 2A of the Arbitration and Conciliation Act. You will find that if a party is not given proper notice of appointment or the proceedings were unfair, they were unable to present their case effectively, that could be a ground for setting aside. It means the arbitrator was unable to manage the process fairly. Corruption and fraud in procuring an arbitration, that is a ground for setting aside an award. The broad one is an arbitral award that is not given in accordance with the Act. It's a broad concept. And the bullet at the top is an expression of our experience while I was at the Commercial Division. I think Section 34 is turned into a scapegoat for many advocates who have not succeeded in the process. They think anything goes. Whatever I raise can persuade the court to set aside the award. We are very careful. In one of my decisions, I said, you take the arbitrator for good or for worse. You chose the arbitrator. They are human. They can make errors just as we judges can make errors. But if they are ordinary mistakes, not fundamental to the justice of the outcome, we can live with those errors. Even our processes are imperfect. That is why we have multiple appeals when we decide. So minor violations, minor experiences of misconduct will not suffice. It has to be something that was so wrong about the conduct of the process, about the conduct of the arbitrator, that renders the outcome unsustainable. Not every wrong, not every error, not every mistake, not every misinterpretation of the law will suffice. It has to be something fundamentally wrong. It is as high as that. We don't set aside arbitral awards on flimsy grounds. And then finally, These are areas that have featured on multiple occasions before the courts of law as a basis for setting aside awards that are related to ethics. Conflict of interest, I gave one example. Ex parte communications, there's a decision that came up where dates of hearing were only communicated to one party until the final determination at one stage of the process. Because he had not filed a certain document, I don't remember what it was, the other party was blocked out from the rest of the process. They said, now it is an ex parte arbitration, you are not entitled to notification. It does not matter that the other party is unwilling to participate. Whatever step an arbitrator takes, they must notify the other party, even when they have chosen not to participate. And it is clear to you that they are unwilling. For as long as it is an ex parte process, it does not mean absence of notification. Continue notifying them. They can come back at any stage and continue. You don't block their right to participate. Unnecessary delays, I've highlighted that when the time elapses and there are disputes over extensions and the validity of the award that is made after an extension. There are issues of compromise where you see an arbitrator struggling to come up with an award that is almost a draw. I think we call it, you don't know in whose favor the award was made. They are struggling to impress both parties to the arbitral award. Enforceability becomes a problem. How do you enforce a vague award? So ladies and gentlemen, I thank you for giving me audience. That is the end of my presentation.
My Lord, you can come and take your seat. Please come and take your seat. Dear participants, let's appreciate His Lordship once more. His Lordship has taken us through a number of our key principles that we as arbitrators or those who are in the practice of arbitration must abide by, and I will not belabor to go through the same so that I do not dilute the discussion. But he has said one important thing. He says that ethics is the bedrock of a just and transparent and credible process. So we need to make sure that whatever is being done in the processes, that is something that we must always abide with, because then you want to avoid a risk of an award being set aside, because what we are looking at here is finality of an award. But he has also raised a very important question: who regulates the arbitrators? And here I'm looking at my beautiful lady there. I will need you to make a comment. The question he raises is, do we need a code of conduct for the arbitrators? And that is something that as well, particularly also what Professor referred to when we are reviewing the laws. Is this something that maybe as Uganda we want to consider and also have it on either within the policies or the frameworks that govern arbitration within Uganda? So I will now allow maybe about 5 questions or interventions. You can ask His Lordship or you can make a comment, and we'll take about maybe 10 minutes or so. So let me first have, if you can have maybe 5 hands up for the start. Yes, my lady. My Lord, the head of the commercial division, you're welcome. Yes, please.
Thank you so much. Thank you, Justice Mubiru. It's always an honor to listen to you. I'm just making a comment with regards to regulating arbitrators. The challenge with ad hoc arbitration, which is the one that is done without an institution administering, is that when you have issues with arbitrators, you get stuck. You have nowhere to report, you have nowhere to go. Now, the advantage with institutional arbitration is that when an issue is raised, it is brought to the attention of the institution, and the institution can take action. Now, as the center, I'm speaking on behalf of ICAMEC. As a center, what happens if an issue is raised? The center will look into it. And something that I should also highlight is that during the course of the arbitration, throughout the entire lifespan of the arbitration that is with the center keeps an eye. So the center is copied into all communications. The center knows every step that is happening. So sometimes the center will pick up on an issue that the parties haven't even picked up on. Now, the center has rules, and we also have a code of conduct. So what happens is, if we pick up on something that is going to affect the outcome or the proceedings, we shall address it, even if the parties haven't raised it. Our role is to administer, but to also oversee and ensure that the process is conducted in a fair way. So when we find an issue, there's a bias. Sometimes, like Justice Maureen said, sometimes even us, the parties will come to us, and I'm speaking freely, right? I can speak freely. You're not going to hold this against me. Sometimes the parties will come to you, and they will ask, but can't you, Madam, the arbitrator, can't you, the contract, we are Ugandans, the other person is a foreigner, can't you talk to the arbitrator at least? They will approach us hoping that we can reach out to the arbitrator. So the issues of interference and trying to compromise the process, those are part of the process. So my recommendation would be, and I'm not saying this simply because I'm speaking from an institution's point of view, but go for institutional arbitrations where there are codes of conduct, there are rules that regulate the process, and there's solutions to when a situation comes in place. For us, we can replace the arbitrator when we find a conflict, or even if unfortunately the arbitrator passes away, we have processes in place to sort of deal with that kind of situation. So that's just my comment.
Thank you very much. You can pass it on to Senior Counsel.
Thank you very much, my Lord, for an excellent presentation. As always, we benefit from your great wisdom and learning every time you make these presentations, so we are grateful for it. My Lord, given the fact that there's such a tremendous, from your presentation, given the fact that there's a focus on ADR in the courts, and given the contribution of my sister, I think the time has come where we should have some sort of general code of ethical conduct. Since most of these what my learned sisters said, these ad hoc arbitrations and mediations, there should be a code of conduct to guide the procedures where these processes are taking place ad hoc. You will find, for example, as you said in your presentation, you'll find, for example, engineers in construction disputes, or during the adjudication, presiding over very complex, very high value disputes, and you find that most of the time they only have a very general sense of fairness, impartiality, and all the issues that you raised in your presentation. So I do think that the time has come, given the fact that all these processes are supervised by our courts outside the institutional mechanisms, that we ought to have some general code, in the same way that, for example, the Central Bank of Uganda has a code of consumer guidelines. How does a bank treat you? How does a bank charge you? Who do you complain to? They even have an ombudsman. So within the court structures themselves, maybe we could have some sort of office that looks at some of the complaints that may arise out of these procedures. And then steps may be taken, for example, to excommunicate people who are known to be bad actors, so that we can ensure that we have ethical processes taking place. Thank you.
Okay. Thank you very much. Yes, my Lord. At the very back, yes.
Thank you so much, my Lord. And yes, I want to add my voice to what the other speakers have recommended we need a code of conduct. But beyond that, as we wait for this code of conduct for arbitrators, we need to raise awareness to our citizens that they should always, those who look for arbitrators, who come before arbitrators, they should ask for certification. Their certification, are they certified with ICAMEC or Chartered Institute of Arbitrators? So then there's accountability at the end of the day. Yeah, in the meantime, I recommend that we do that. Thank you.
Let me just have one last intervention. Yes, sir.
Yeah, thank you. Patson Arnaito is my name. Thank you, my Lord, for the exposition provided, especially on ethical issues. My Lord, there are quite a number of what I would call soft instruments that have been developed over time relating to ethics. For instance, we have the IBA Code of Conduct, I think it's 1988. Of recent, we have the Conflict of Interest IBA guidelines relating to arbitration. Now, the laws we have, most of the domestic statutes, have broad principles of impartiality and independence. And my question, I'm wondering how receptive are courts probably to draw inferences or lessons from these soft laws? Because I could understand, I think, the case you've highlighted. You could tell the dilemma as you're writing the judgment in terms of how far broader do you go. Judiciary has its code. It might be difficult with arbitration. Probably more than 70% of arbitrations in Uganda are ad hoc. And some of the arbitrators may not necessarily even be trained. So when you develop a statute which is probably court-based, how are you going to draw these independent parties to come to subscribe to that court? So the concern is in probably setting aside proceedings or annulment, how far can courts draw inferences from some of these tried and tested international instruments? I think that, like the conflict of interest, we have the traffic light system that highlights what should be disclosed, what may not be disclosed, and the extent of the ethical concerns. Thank you.
Participants, you'll forgive us, time is fast spent, so I'll ask His Lordship to make some comments and then answer the question from Council, and then we'll close the session. My Lord, you're welcome.
Thank you very much for the interventions. I'll respond to two of them. I think the others were recommendations of what ought to be done in terms of codification. The recommendation that courts should be able to supervise and monitor arbitrators and perhaps sanction them, unfortunately at the moment is limited by statute. Section 9 of the Arbitration and Conciliation Act says specifically courts are not to intervene in matters of arbitration except as provided for under the Act. So when you examine the Act, there are only 9 areas where a court can intervene, and none of them confers disciplinary powers over arbitration or arbitrators. So if we are to exercise any type of disciplinary control, we would be going outside the mandate given to us by statute as courts. So if the courts cannot intervene to monitor the process, they can't discipline arbitrators for misconduct, but they can set aside, or I think there's only one area where they probably could consider issues of misconduct, where there's a decision on an objection or a challenge raised and someone is dissatisfied. The law allows a party to appeal or apply to the court for purposes of reviewing decisions related to jurisdiction and challenges to jurisdiction. That is the limited area. So we are limited by statute. We can't engage in disciplining, supervising, and monitoring the behavior or conduct of arbitrators. Certification requirements, I think, is a good recommendation. Codification, too, as well. How do we apply international or principles embedded in codes internationally and regionally as well as domestically? Adopting principles from elsewhere is a delicate area of practice for judges because, as I said, ethics is a reflection of values of a particular community. Those values may not necessarily be identical to ours. So in order to adopt a principle from a foreign jurisdiction, it must be comparable to a domestic practice at the least. There has to be a track record of a practice that is similar to what is happening elsewhere. If you have evidence of that practice, then you are comfortable using that as soft law to augment your decision. But in the absence of that practice, we can't simply bring into our jurisdiction principles that have not been generated from our common understanding of what is ethical. We would be legislating from the bench, and we can't do that. We can only apply what has been accepted, what is clear from practice. So it's the reason we need the practitioners to have an indication of what they perceive in Uganda is acceptable and unacceptable conduct. Codification is the way to go.
Thank you very much, my Lord. Now, just allow me to take one more intervention from Madame Barbara. She's one of the partners here, so if I don't allow, we might not have lunch. So, Madame Barbara, please.
Thank you, and my apologies for making you vary your previous order. Judge, I'm just interested in your perspective on artificial intelligence, especially on its effects in ensuring that arbitrations remain ethical. And what should arbitrators do when using these tools to improve either their efficacy or even undertake some of the initial processes of arbitration during the discovery processes. So thank you very much. And their word writing. I'm very sorry that that is influenced from my partner here, but thank you very much for indulging me.
Thank you for the question. As I said, I've never been an arbitrator. I speak from the experience of the bench, which is more or less similar to that of an arbitrator, in my view. I think IT helps as a tool. It's just a tool. The line it should not cross is taking over the autonomy or the decision-making ability over the person presiding. You use it as a tool in two ways. Maybe that is how I use it myself. First, to make processes cheaper and faster. For example, if parties cannot come easily to the venue for the arbitration, video conferencing could be an option. They can submit their evidence from wherever they are and participate in the process from wherever they are. You don't have to adjourn for their failure to convene at the venue. That is one way of filing documents, reviewing them. All these tools can be applied to cut short the cost and rather cut the cost and the time it would otherwise take to do it physically. Second, it is in research. There are areas where you may not be able to go physically to obtain information wherever it is stored. There are open sources of information on the net. There are tools for doing that kind of research. I've used it many, many times when I'm doing what would have been library research, going to a library, searching for a law report, and reading it. You can use it for that purpose. But there is a danger sometimes you don't take the first search response. When you put in your query and get a response, you don't know where the information is coming from. So you go behind that initial response from IT and look at what sources has this information been generated from? On occasion, you'll find that the source of that information being given to you is questionable. So you will not take that as the true position, either of law or fact that you are searching. So you double check and go to the origin. There's a function in some of the software where you can check for the sources, whether they're original and whether they are dependable. So it is a tool, but you should never come up with a decision. I've seen some people entering queries into the search engine, get a response, cut and paste that response as the decision. And many times you'll be embarrassed when you find that it is quoting sources that are questionable. So it is a tool, but it should be used with caution. And it will be a vital tool in arbitral processes, just as it is in adjudication.
That marks the end of this session. Let's put our hands together and appreciate His Lordship once again. My Lord, thank you so much for the time. It is always an honor to sit at your feet and learn. And I'm sure that all of us have picked one thing or two that we are going to use on this journey of arbitration, but even us who are in the courts of law. So thank you so much, my Lord, for the time. Okay, Secretariat, over to you.
In the spirit of disclosure, it is just a notebook. There's nothing else. And the notebook has no notes. So don't worry. It is an empty notebook for writing. Okay. I'm requested to request humbly Justice Anne Mugenyi to kindly come and assist us with the award ceremony and the photo. Ladies and gentlemen, a round of applause, please. Ladies and gentlemen, once again, thank you very much for your patience. We are breaking for a working tea. I will define it so that it is clear. It is to pick your cup of coffee. Please come back so that we can start with the next session in the next 5 minutes. Thank you very much and looking forward to the next panel. Asanteni sana. Tea is served. Since most of you are still seated, should we proceed maybe with the next panel? There's no interest to have tea? That would be ideal. No? The protests have, the noes have it. They've all stood up. Okay.
It's now my distinct pleasure and honor to declare the Alternative Justice Systems Capacity Building Workshop officially open.
We must respect other places where disputes are also decided. But not only respect, but we must bring them to the table and have a conversation with them. And the AJS is precisely about facilitating that conversation. It is about empowering the other key justice actors, and the training today is about telling you what the justice system is all about.
If AGS was not working, the judiciary would be having 1,670,000 cases. But what AGS has done, it has taken 90% of that. And that is why we have 10%, which is 167,000 cases. So it is important that this conversation is considered seriously.
ADR is a solar system. At the center is the Judiciary of Uganda. So it is like the sun. So the leadership of ADR through this AJS is firmly in the institution of the courts and in the hands of judicial officers.
Alternative justice systems are not mere alternatives. They are the foundation of societal harmony. They are systems rooted in indigenous traditions, cultural norms, and communal values, and encompasses mechanisms like the elders' councils, clan-based reconciliations, and religious arbitration that have resolved disputes for generations. We must evolve these systems to ensure they complement rather than compete with our formal judicial practices.
Let people know the beauty of ADR. Let it be people to come and say, okay, he has brought this matter to court. We have not tried with our community leaders. Let it come. You know, the moment we can reach that stage, then we have hit it. I ask judicial officers, urge the parties, educate the parties, tell them the beauty of a negotiated or mediated settlement. Tell them, please go and try before we hear.
Community justice, as we have seen, the evidence we have gathered shows us every day that community justice prioritizes the outcome and promoting social threat. And this process then definitely ends up serving the demands of justice and ensures that it has responded to the issues that are raised by the different community members.
What I see from the decision, it clarifies that traditional justice mechanisms cannot replace or hold formal criminal trials, but they can be the framework for either plea bargaining or ensuring that satisfactory criminal sentencing and the like arises.
Undeniably, religious leaders play a pivotal role in alternative justice systems and ADR, offering a unique, a values-based approach to conflict resolution that draws on spiritual authority, moral guidance, and community trust. Our involvement in AGS and ADR is deeply rooted on the Holy Scriptures of our diverse faith traditions as represented in this training.
Good morning. Welcome to day 3 of the Gumzo La ADR Conference. Today, we are focusing on a masterclass on construction contracts and adjudication of construction disputes.
There is a deliberate high-level effort by the government of Uganda and the judiciary to institutionalize ADR across all government entities. This aligns with the national ADR policy, which envisions a shift from traditional litigation to more collaborative settlement mechanisms within the MDAs. Judiciary now boasts of a pool of retired judges serving as mediators and adjudicators. The Judicial Training Institute stands ready to organize tailored trainings for MDAs to sharpen these skills further.
The construction industry contributes about 7% to our GDP. Our construction contracts operate under various forms, we have the FIDIC forms of contract. But however, what is common with all these forms of contract, disputes still arise from delayed payments. We have delayed right-of-way acquisition, like us in the road sector. On behalf of the ministry, this training is timely. It should build the capacity of our project managers, policy makers, and other professionals to anticipate dispute triggers.
If we train our people and we are able to handle our solutions, we shall not waste a lot of time in the courts. You find a project like maybe Mpiji Busega, if we have a dispute, the money is there, but because the parties are quarreling and they go to court, the case keeps on, So with more training and with more hands of registered engineers, we should be able to go past this one.
So within construction, there are a number of risks that can actually be eliminated. And so the contract helps us to eliminate them by properly demarcating the roles of each and every person, the procedures, the timelines, and the checklist on what we do to ensure that that risk is completely out of the picture.
One of the first things that the contract administrator needs to do is to understand the contract inside out. And so the flow of information is very, very important. Managing this flow of information will contribute to the success of the project. Issuance of RFIs and the turnaround time for the response to them must be adhered to.
When you're preparing the particular conditions, you must make sure that the clause is clear and unambiguous. The general conditions provide that there shall be arbitration in Kampala. So you got the special conditions and you say there shall be arbitration, but either party may go to court. So you have created an ambiguity in a sense that the parties did not agree 100% that arbitration will be their final method of resolving.
As Africa celebrates infrastructure development, we must ensure that disputes do not become barriers to progress. Instead, they must be managed constructively and resolved efficiently.
On behalf of the organizers, I would like to extend our sincere appreciation to our presenters for the insightful presentations on construction contracts and adjudication of construction disputes. Your expertise, practical perspectives, and thoughtful analysis have greatly enriched our understanding of the complexities involved in these contracts and resolving disputes in the construction sector. And thank you all for coming.
Ladies and gentlemen, would like to move on to the next session. For those of you who can hear me outside, please let's maintain the idea of the working tea as announced earlier. Eddie, if you can help me usher our people back because we are short on time. Ladies and gentlemen, today is about domestic arbitration. We started the morning with a high-level Gumzo breakfast, which involved our counterparts in the banking sector, attended by which was presided over by the Lord Chief Justice, and also attended by the Honorable Minister of Justice and Constitutional Affairs, and several Lord Justices from the Commercial Division. We heard from Professor Muigai, who gave a keynote address after that, and then that was followed by Justice Stephen Mobiru, who took us through ethical arbitration as a key driver for successful domestic arbitration. So my role is to invite our next moderator for the coming session. He will tell us what it's about. I'm not really sure that he needs introduction, but it's only fair that I say one or two words. Mr. Moses Adrico, Senior Counsel, is very well known to all of us. He's been around the scene for many years, senior lawyer. He's the managing partner at AL in Uganda, Marks Advocates, a certified arbitrator, a big brother, senior lawyer, and he holds many titles. He warned me not to say many things about him because he insists that you are not here to listen to him. Senior Counsel, Adrico, the floor is yours, sir.
My younger brother, Moses, thank you. Good morning, colleagues. Good afternoon, colleagues. I'm going to now welcome you to a very scintillating and probably very highly anticipated and awaited panel in which we are going to discuss how domestic arbitration is shaping investment decisions in Africa. We have a very distinguished panel of people who have got broad experience as practitioners, as people who sit and receive investors and who understand intimately the concerns of investors, as from Uganda and from across and from our sisterly republic in Rwanda, and as well as a very accomplished business person who's had extensive experience in navigating the various issues in our business, in our local business landscape, obviously with investment, with substantive investment implications. If I may, if you may allow me, I would first of all like to invite up onto the stage Mr. Andrew Rugasira. Andrew is the chairman of eTransact platform in Uganda. He's a well-known entrepreneur. I think all of you have read his book, Good African Coffee, Good African Story, which was born out of his experiences as one of the leading coffee and cocoa exporters out of Uganda with his company, Good Africa Coffee. Andrew is an entrepreneur, author, a strategic advisor, and the founder of AMR Group, a boutique advisory firm that supports investors, companies, and institutions in navigating complex markets right across the continent. Andrew holds a law and economics degree from the University of London and a master's degree in African studies from the University of Oxford. I would also like to invite up to the stage Mr. Peter Muramira. Is he in the room? Peter? I was with him yesterday. He travels a lot, but I'm sure he's this time he will not be with us online. Peter is a public sector specialist with extensive experience leading sovereign and corporate finance relationships, global banks. Peter has been a director at the Uganda Investment Authority. You all know what the Uganda Investment Authority does. He's had over 15 years experience promoting our country across all different sectors, FCMG, banking, IT, and so on. Peter holds a MSc in Development Management Sciences from Leeds. He's currently undertaken an MBA at Heriot-Watt University. He holds a postgraduate diploma in project planning, and he's a graduate of Makerere University, Public Relations and Politics. Peter has a very long bio, but you'll allow me to stop there and introduce our next panelist. Our next panelist, Mr. David Njogona Joroge. Bwana David, are you here? Yes, you are. Thank you. David is an advocate of the High Court of Kenya with over 10 years legal experience. He holds a Bachelor of Laws from Makerere, our very own Makerere, a postgraduate degree in law from the Kenya School of Law. He's a fellow of the Chartered Institute of Arbitrators, an ADR practitioner, and as well as an accredited mediator. David is the current vice chair of the Chartered Institute of Arbitrators Kenya branch. He's also a member of the State Corporation Appeals Tribunal and serves on the National Steering Committee for the formulation of ADR policy in Kenya. And he was appointed to that position by the Attorney General of Kenya. He's a senior partner in Njogona & Njogona Advocates. He's also a council member of the LSK, and he's a pre-qualified ADR tutor at the Nairobi Court of International Arbitration. Online, I have a very, very distinguished panelist, Ms. Claire Akamanzi. I'm sure you're all familiar with her. Claire is the chairman, the NBA Africa CEO. So she, and this is a recent appointment. It comes after extensive experience at the Rwanda Investment Board, where she was a CEO for 6.5 years. Rwanda Development Board, I beg your pardon, where she was the CEO for 6 years. In her new role at the NBA, she's overseeing business and basketball growth of business and development efforts in Africa, is responsible for continuing to grow the popularity of basketball across our continent, and this includes grassroots basketball development, media distribution, corporate partnerships, and social responsibility initiatives to improve the livelihoods of African youth and families. Before she was at she's also worked as the Chief Operating Officer of the Rwanda Development Board and Head of the Strategy and Policy Unit of the Office of the President of the Republic of Rwanda. Claire holds various degrees, including a master's degree in public administration from the Kennedy School of Government at Harvard University, where she was the recipient of 3 prestigious awards. She also holds a Master's of Law degree in International Trade and Investments at the University of Pretoria and a Bachelor of Laws degree from Makerere University. She has been recognized as one of Africa's top 50 powerful women by Forbes in 2020. Ladies and gentlemen, distinguished attendees, that's your panel this afternoon. And perhaps I could start by asking Claire to speak to us about her experiences with respect to attracting investors to Rwanda and navigating their concerns with respect to resolution of disputes. I know you are quite instrumental in setting up the Kigali Institute of International Arbitration, and we want to hear what your experiences are and what were your principal concerns and what were the principal things you had in mind when you were setting up KIAC in your role as at the Rwanda Investment Board.
Thank you very much, moderator, and I hope you can hear me well. Greetings from Nairobi, where I'm based, and very good to see a lot of familiar faces in the room. Yes, thank you for the introduction. My job today is to promote basketball in the continent. But yes, again, thanks for the introduction about my previous job, which was very much around creating the right investment environment to attract business in Rwanda. And maybe that it's in that context, in that previous job, that I will be speaking mostly. And one of the responsibilities we had at the Rwanda Development Board was to build a business environment that investors would trust and would find conducive for them to deploy capital. We were at that time, looking at how best to attract big-sized projects in infrastructure, energy, telecom, mining, among others, that required a lot of capital. And we got feedback from investors we're talking to on what they expected in order to deploy capital, both in terms of the size of capital that we're looking at, but also for long-term projects in infrastructure, among other industries. And so we went out to build what we called, doing business environment for Rwanda. And we used the World Bank Doing Business report at the time as a guide. And we looked at, what investors think about, mainly 2 big prospects. One, what is the actual opportunity? Can I make money in that country? And then 2, if I can make money in that country, is the environment conducive that I can actually deploy capital for a long period of time? And this is when issues around, predictability, legal legislation, institutions, etc. came around. And particularly for one aspect that we called enforcing contracts, which was one of the areas that we focused on. We then decided to work with the Ministry of Justice in Rwanda to begin to think about setting up an arbitration center, which was not existent at the time. But what were we trying to respond to? Maybe I'd say 3 or 4 things that we're trying to respond to that was very clearly what investors were telling us for them to really deploy their money in the country. One is that they wanted to make sure that we had institutions that could support dispute resolution. So once they thought the opportunity was there and they could put their money there, the next thing is, okay, in case something went wrong, can I trust a system that would allow that to happen? And some of the factors that they said us, again, the 3 or 4 factors. One is there an arbitration system that is independent, that the court system respects? That if we go to an arbitration center and we get an award, that award can actually be respected. In fact, I remember at the beginning of this process when we just set up the center, people would lose a case in the center and then they'd go to court. And sometimes the court would listen to those cases. Eventually that changed, and the system and the courts really built capacity, and they also really started truly enforcing awards coming from the arbitration center, so that they could give confidence to the arbitration rather than replicate what they could have been doing in the court system. And so that independence was very important, and investors said, look, I want to be sure that when I go to the arbitration center, courts will respect that, they will enforce it, and that they will support the alternative dispute resolution that is there. So that was one thing that they were looking for. The second thing is, did they have international standards? Were we aligned? And so we went to look at the model laws, the ancestral model law and many others, so that we could assure that the laws that we had in place were aligned with international standards. And also when we were doing negotiations with investors, some of them asked for international arbitration, ICSID, among others. And we did, many times, were open to international arbitration. But we also knew that international arbitration can be expensive, and they did mention that. Some of them wanted arbitration in international cities, that really just maintaining a case there would be expensive. And so it was very important that we were able to build capacity domestically as well, so that you can have more people access the centers. And so we set up the Kigali International Arbitration Center basically to really build domestic capacity, and you can actually do more cases and have better costs associated to that. But then international standards and just predictability of what to expect was important, and many of them raised that when we're negotiating investment deals. The third one is professional institutions, and that's what really Kigali International Arbitration Center at the time sought out to do. Building institutions that are strong, that are efficiently managed, that have good administration, that have very skilled people, that have good experiences. A lot of times, some of the deals we worked on were very complex, and so skilled people that had experience in such international complex deals, and they could actually resolve them in domestically. So really, just making sure that the institutions and the people that were running the institutions, or the arbitrators that were there, were actually skilled and experienced was key. And they wanted to look at who is there, what kind of skills were there as well. The last point I would say is efficiency. At the end of the day, investors wanted arbitration because they wanted a quicker way than traditional courts. And so really delivering that, making sure that the processes, the arbitration center was, had very clear procedures, they were efficient, they were quick, and that speed was very important, because otherwise to defeat the purpose of wanting to go that route. And so when we put that and really supported that, understood what the investors were looking at, and really built the system, I think it's still really growing. That really gave us a very good chance when we're negotiating deals, and telling investors, not only can you make money from the environment we're building here, but also you can trust our legal system, you can trust our arbitration system. We bring credibility and we bring professionalism, and building that over time and continuously improving that was very important as we thought about long-term investment attraction as well. I'll pause there for now. Thanks.
Thank you very much, Claire. I will now switch to Peter. Peter, you've heard what the gold standard for Rwanda was when they were setting up their country as an investor destination. And my question to you would be, have we reviewed our investment laws? And how is Uganda working with the justice sector stakeholders to ensure that domestic seats for arbitration are promoted as the first option in new investment, in awarding new investment licenses?
Thank you very much, Mr. Moderator, and thank you, the organizers, for this platform. I bring greetings from Uganda Investment Authority. We are an investment promotion agency, which invites us to, at the head of everything else we do, is to advocate for the investor, be it local or domestic or foreign. So we try in the all circle of events that we do to try to align with what the investor is thinking. And what we have picked from the last kind of, I would say, 10 years, because the terrain again keeps changing, given the global dynamics, we see the demand coming around the expectation of experience. How does the investor feel when they come in the country? Do they feel that we are accessible? Can they trust the system in terms of credibility, in terms of knowledge, in terms of proactiveness in listening to them? And key issues that have come up are broadly in the areas of litigation and arbitration, policy inconsistencies, be it around taxes, be it around land disputes. We see that there is a gap in terms of interpretation when, as Uganda Investment Authority, as a one-stop center for government, across all ministry departments and agencies, interpretation of guidelines exposes us a little bit, and it is my prayer that as we get along, we develop a mechanism that will boost that kind of confidence in terms of making sure that all centers of authority, be it those that manage data, be it those that have the permission to speak on behalf of this government here or abroad, have got at least some good knowledge of the facts on the ground. The other issue that comes out very predominantly, also related to this, is the cost of doing business. Making it very easy for both the investor and the partners locally is important. And again, I talked about experience. So at Uganda Investment Authority, we have devised means of working very closely with, be it the International Center for Arbitration and Mediation, be it the Justice, Law and Order sector, be it the Uganda Law Reform Commission. And I speak this because we also have a dedicated champion who coordinates all these agencies under the umbrella of Presidential Investment Roundtable, PIRT. We are very cognizant that these issues that are discussed cut across all sectors, be it in agro-industrialization, be it in mineral, be it in tourism, be it in ICT, as the ATMs guide us as policy of government. But more importantly, we are trying to deal with the issue of expertise and efficiency, because we believe that's where it starts from, that the length of time these investors spend to try and get to be understood costs them money. From the point of just staying in a hotel for a week in Serena while they are waiting to get an interpretation from URA or get a clarification from Uganda National Bureau of Standards, we believe that this can be shortened. And yes, we are working closely with these organizations to de-risk and remove the bottlenecks that frustrate the investor at the point of entry. At the back of our mind, we also work very closely to ensure that there is neutrality. Neutrality as these discussions happen, and we pray that the organizers here can also lead us into specific angles where we are seeing the ADR policy come into place, bearing in mind, though, that we are charged to make Uganda a friendly environment that attracts investment, that attracts tourism, that attracts and retains investment for a long term. That's what I can say for now.
Thank you Peter. It's very reassuring to know that all the issues that have been addressed by Claire are very much within your mandate, and that there are progressive steps being taken to address the gaps that perhaps prevent Uganda growing up as within the domestic arbitration space. I'm going to ask Mr. Njoroge Jogona in his presentation to address two questions. And the first question is, what is your experience with respect to domestic arbitration in Kenya, and what have been the drivers for adoption of domestic arbitration? And the second I would want to ask you is, when foreign companies look at the Kenyan market, how much weight is given to the local seat of arbitration versus the traditional preference for London, Mauritius, or Paris? Thank you.
Thank you for the good question, and it's always a pleasure to be in Kampala. It's a second home for me, and the good things about Kampala can never be overstated. Now, as I want to speak as the Vice Chair of the Chartered Institute of Arbitrators, and the interface that we play with the government and also with all the justice sector players to ensure that, one, that we attract international investments, and that we ensure that Nairobi is a safe seat for arbitration. As the Chartered Institute of Arbitrators, of course, we are the premier in terms of ADR promotion, training and accreditation, and basically spreading the gospel about ADR. We have partnered very, very sentimentally with the judiciary, and our CJ, Her Lady Justice Martha Koome, is our patron. And just to show the far that we have partnered with the judiciary, if you look at the Supreme Court of Kenya today, all of the 7, now 6 judges of the Supreme Court are fellows of the Institute. And that is a big win for us because looking from out, an investor will see that the apex court of the land, they are all actually trained in matters ADR, in matters arbitration. You all know the certifications under the FCIAB, we do not grant them, it is the UK. So they actually sat for the Module 4 exam under ARF, accelerated route. Of course, we were holding our hands to ensure and pray that they all pass, and they actually did, and all of them are now fellows. So what does that speak? That speaks to the international world that Kenya is a safe seat. What she has done after that, she has cascaded it downwards, and especially the key stakeholders in terms of the division at the High Court, like the Commercial and Tax Division, which basically handles matters to do with ADR. They have also enrolled and are also being trained matters ADR. We have been having discussions with the CJ to have a specific dedicated division to handle matters ADR. We have noted, due again to our backlog issue, in Kenya we have currently a backlog issue of 635,000 cases. So you can imagine even simple applications that we do in terms of arbitration to basically complement with the judiciary, where maybe you want interim orders, maybe you want an arbitrator to be removed for one reason or another, or appointment. They are very simple, come under miscellaneous. They ought to be turned within 60 days, but due to a backlog, they end up even staying for an year or so. So we are at advanced stages of having a dedicated division which will be basically be manned by a person well-grounded in arbitration, and will be turning these cases in the shortest time possible, like in 60 days. That will ensure that whenever there is an arbitration, there is a question to be addressed by the court, then you're not going to court and be held by the backlog of the cases, but there is an expedited a way of doing this. So those are some of the interventions that CIAB is partnering with the judiciary to ensure that we make Nairobi a safe seat. Of course, we are also partnering with the government-led Nairobi Center, International Center for Arbitration, and its mandate also is to make Nairobi a safe seat. Like, for example, last year we partnered and we had our international conference together. So we basically look at what are the stakeholders involved in all these aspects. We come together, we want to speak with one voice because our common objective, all the players in the country, despite the outfit, despite anything, our common objective is to make Nairobi a safe seat and ensure that foreign direct investment is assured. And when an investor comes, looks at the ADR field, he can see and he can be confident that there are vibrant institutional and ad hoc options in arbitration that will ensure that the matter will be heard and determined. When you look at the judiciary, you can be assured that we have fellows sitting in there and we have a judiciary that will be positively responsive and supportive to complement the ADR. Thank you.
Thank you, Njoroge. Andrew, you have been a vocal advocate for African brands and indigenous capital. How can we use domestic arbitration policy and legal frameworks to empower African SMEs to negotiate fairer dispute resolution clauses when partnering with larger global entities? In other words, how do you make it easier for our local SMEs to partner with international companies or international partners within the framework of the domestic arbitration regime that we have?
Thank you, Moses, and good afternoon to everyone, and thank you for having me here. I think the first issue is to recognize that the relationship between an SME and a multinational is one of an asymmetry of legal power, of financial power, and so it's rarely a fair negotiation from a business point of view. And so I'll give you an example, two examples. In 2010, one of our containers of coffee that we're exporting to Felixstowe was attacked, the ship was attacked by some Somali pirates. So the product couldn't get to Felixstowe and couldn't get to the supermarket on time. So they then canceled not just the order, but the placement on the shelves. So where would I seek resolution of that? You read in the contract that it says, the arbitration clause said that any dispute resolution should be handled in London. You're an SME in Uganda. You have enough issues constraining you here from the production, the supply, the logistics. How are you going to resolve a matter like that with a large multi-billion-dollar multinational supermarket chain? That asymmetry affects your potential to do business in the global market. Another example, I'll not mention the company, but in 2016, we signed a Pan-African contract with a large European company to put small coffee corner shops across their, I'll say, quick service stations across Africa. They had 5,000 of them. So we signed a contract and it was exciting. So we did some pilots in Cameroon, did some other pilots in Ghana, did some pilots here, and we're exploring doing a pilot in Nigeria. A year later, the vice president of that organization left to go and work in another company. And all of a sudden, the appetite for that project, for us, it was a matter of life and death. For this company, it was just an investor decision that the new guy didn't feel that, it was something they really wanted to do. They could build little contracts with other coffee suppliers in each territory. And we'd invested so much. But at the stroke of an administrative transition, the project was was dead. The contract was this size, it was 100 pages. But any dispute resolution would have to be done in Paris. We couldn't afford a Parisian lawyer. We couldn't afford to go to Paris and have this matter addressed. So that shows you from the export, the international trade sphere, it's very difficult for an SME. Now, if you look at locally here, I think if investors are able to find an effective institutionalized dispute resolution here in Uganda, actually capital will come. And it's interesting to see that capital moves to a territory less because of tax incentives and more for the risk that they price for certainty. If there's certainty, capital will move there. If contracts can be enforced, if disputes can be resolved in a timely manner, and if there's an impartiality in the system that resolves those disputes, then capital will move. So with a robust the resolution infrastructure in Uganda, you'll find that capital will be able to move here because, one, they have that certainty that if there's any dispute or anything that comes up, it will be resolved. At the end of the day, investors price risk. They don't just price the tax incentive that they get. They price the risk for their capital being invested. So anything that creates that certainty in the local economic environment will attract both capital and will boost opportunities for SMEs. And that also affects their ability to access capital. Long-term capital is assessed where the provider of the capital measures that the risk is less, there's certainty in any resolution mechanism there, and that the long-term benefits far outweigh the risks. Thank you.
Thank you very much, Andrew. Claire, I'm going to go back to you because you've heard from a business person, the person at the sharp end of all the work probably you were doing in Rwanda over many years. And my question to you is, from your experience, do you think that domestic arbitration is often sold as a cheaper, faster alternative to international proceedings? And is it the case that in practice, these domestic proceedings, arbitration proceedings, may be bogged down by litigation-style tactics? So in other words, what were the procedures, what was the environment in which the international investors were operating in Rwanda to ensure that they felt safe, they had priced that risk that Mr. Rugasira has just spoken about and felt comfortable with the systems that you set up?
Well, I think, just like the previous panelists have said, investors always, measured risk and they looked at it at different angles, political, regulatory, dispute resolution, etc. But what we always heard from the investors is they wanted to understand if there was enough track record locally in the domestic systems that would give them confidence. And of course, it was a new center that was being built, new laws, and so we had to build credibility over time. And that credibility and track record was the cases that were being handled, how long they were taking, some of the resolutions coming out of the centers. And every time we talked to investors, they wanted to understand, okay, how many cases have been done there, how many arbitrators have been involved there, what are their track records, etc. And so for me, domestic does not really compete with international arbitration. I find them complementary, and I think they should be complementary. But to bring the domestic arbitration centers as a trusted confidence layer, it needed time to build that and the track record to do that. And that's the building that has been happening in Rwanda, and a lot of progress has been made around that. And once investors see some of the cases that have gone there, once they've experienced it, once they can share their experiences with other investors, then they get more credibility. But as you're building that, the system was complemented with international arbitration. We still had investors that said, okay, fine, I still want to do London, Dubai, Mauritius, etc. And we would be open to that because we knew we're building systems to do that. But once they saw the progress that was being made, the track record that was being built, Then they started to see that as more credible, and we got more and more cases going through the arbitration center. We saw that growing. We brought international experienced arbitrators from different parts of the world to come and be part of that and bring their experience and really reduce the learning curve. And all of that continuously built credibility. And I think that, that's something that is going to grow and improve over time. And once that track record is getting clearer and more credible, then you have, the risks associated with the domestic systems or the domestic centers reduce over time. And ultimately, once the domestic system is well built and it's credible, investors actually prefer that if they can trust that it's going to deliver the results that they think is fair. They prefer that because, as has already been said, the costs of doing that, the costs of not having to travel to London or to New York or to Mauritius or to Dubai, hire international lawyers, if you could rely on international lawyers to defend you. All those things really bring the costs down, and you can actually resolve a lot more than you'd resolve if you depended on international arbitration. So investors just wanted credibility, they wanted track record, they wanted consistency, predictability, and once all of that was continuously built, we felt like more and more of them were trusting the local arbitration centers and getting their cases there.
Thank you very much, Claire. So I go back to you, Peter Muramiran. This is really, you've had perhaps the best practice. Clearly, Rwanda is a model for all of us across the region. What are your comments with respect to what Claire has just said? Take into account the role your organization plays in this particular space.
Yeah, thank you very much. So we have two issues that we're dealing with. On one hand is the consistency and building the confidence of the investor. But on our side, as entities of government, when we talk about the one-stop center, what is it that is coming out of the one-stop center? So we are going to a point where we think that we need a system that is built on the principles of credibility and trend, so that we are able to speak to numbers, we are able to speak to evidence, we are able to speak to information that we gather over time, and we are able to defend. So as Madam Akimazi says, the Uganda Investment Authority also has built a system where we believe that we can pick these early warning signs early. And this is through an electronic and digital system for enabling monitoring and evaluation, so that we embed in there a platform that will give us triggers to what could potentially be a grievance. And this platform is available to investors, local and foreign, so that then we can start building that. We believe that this will be a good point of collection for both those that are in the process of arbitration, but also those that are implementing investment as local investors and foreign investors. I just wanted to mention that when we talk about an investor finding a respected kind of environment, tried and tested, and when we talk about investor confidence, this is not something that is going to come from only one arm of the government. It's all going to be a case of listening to who is actually providing information, how quickly we are providing this information. Any delays can equally be taken as denial, so we need to be assembled in a rhythm that is proactively engaging with one another, and that's why I'm encouraging at every forum I go that there is now the password at Uganda Investment Authority for relationship management, be it in the face of the investor, be it as entities of government together. We need to improve on how we relate so that we can quickly share uniform information, because in the eyes of the investor, we are one, and that cannot be taken away from those that are here. we need to build those synergies, we need to speak together, and that's why forums like these are very important, so that you can easily make knowledge available to all those stakeholders that are involved in the value chain and the journey for investors. Thank you very much.
Thank you, Peter. Mr. Njogun, I go back to you now. You've just heard from the people at the investment centers. You've heard from Claire, you've heard from Peter about what they're trying to do to create safe spaces for investors, how they're trying to promote domestic arbitration. You've spoken to us about what you've done with respect to the work you've done with the judiciary in Kenya. You've talked about some of the legal reforms. Professor Gizo this morning talked about the fact that you're one of the first adopters of the model law in Kenya. My question to you is, having heard everything they've said, what else should we do to make our countries safe seats for domestic arbitration?
Thank you for the question. I think it is very clear that domestic arbitration, how we handle and how we manage it, is a big indicator to the investment that we may want to attract from the foreigners. So ways of managing this are very, very critical. And one aspect is to call upon all the players in the ADR world, be it CIAB Uganda, be it ICAMEC, be it ALP. They must come together and speak with one voice and have that common agenda of ensuring and helping the government in terms of policy making. In Kenya, we are always consulted and we are always given a seat as CIAB whenever there are matters to do with ADR. So you must sit at the table because your voice, your guidance is very, very important. You will only be invited in that table if you have organized yourself, you're not defragmented, and you're speaking with one voice. That is very, very critical because policy informs the government's vision. The other aspect is to do with ethical standards. It has been discussed here previously. To me, I take it as an arbitrator, your biggest asset that you have is your reputation. So if you spoil your reputation due to issues to do with corruption, non-handling of matters you will not get appointments in future. So it must start with us as arbitrators. How are we conducting ourselves? Matters to do with conflict of interests. It is an incumbent upon us to disclose. I like Judge Mubiru when he disclosed that aspect of from 1974 of the teacher, but he had the duty to disclose. Then let the parties decide. It is much better when you disclose rather than when the parties come to know of it and now they place it as a challenge. So it is incumbent upon us. But further to that, what are we as institutions doing? As CIAB, we all know that we are governed centrally from London, and matters to do with ethical standards are held in London. But what do we do as the branches? It is incumbent upon us because we have that role of appointment of arbitrators. We cannot let our ad hoc arbitrators' appointments go rogue. We have a duty to ourselves, to the clients, and also to the arbitrators. We must maintain a role that is having arbitrators who are credible and who are well respected in the field. So what do we do? In Kenya, despite the fact that in ad hoc, once an appointment authority has appointed, you are funked as official, we have continued to maintain an open avenues of feedbacking from the parties. At the end of it, we actually do an exit a survey just for the parties to share and counsel to share what was their experience with the arbitrator. That informs us, and it helps our arbitrators to know that somebody is checking them. So we are not entirely helpless in terms of managing. When matters become now serious in terms of disciplinary, that is when it can be escalated. But I believe as local branches, we have a role to play and ensure that, that we follow what the law, and of course guidance like IBA principles are all there to guide our efficiency. And lastly, the rules that we make, how responsive are they to the user? We reviewed our rules in 2020 and we brought in an expedited arbitration, the documents only, which is bound for 90 days. We are now in discussions to talk. We have the small claims court in Kenya, which handles less than 1 million claims, which has been a game changer in terms of access to justice in Kenya. We are now thinking as arbitration that we should have small claims arbitrations of less than 1 million, so that we can also manage the issue of costs and ensure that whichever dispute that you have and you had chosen arbitration, then we will give you a small claim arbitrator who will be able to take it round. Like small claims court, it is within 60 days you have your judgment and you can execute it. So those are some of the interventions that I would advise. Partnering with the government, being at the table, being at the policy-making table, that will ensure, because all of us are facing and looking forward to that common objective. Thank you.
Thank you, Mr. Njuguna, for your excellent suggestions and very innovative ideas about how we can make our seats safe for investment. Andrew, you've heard from the policymakers, you've heard from the best practice, you've heard about the initiatives that are being made in our neighboring country in Kenya. Do you have confidence now, as a business person, while advising your client, while you're structuring your investments and you're advising on investment and trade, that we are moving in the right direction?
I think there's no other direction that we have to move than strengthening ADR here in Uganda. I read somewhere that I think, is it 6 trillion shillings worth of cases in the backlog? That's about 3% of our GDP. It's not about legal reform. I mean, it's about really economic efficiency. And it's an absolute necessity. But I think at this stage, ADR remains at a conceptual level in the mindset of a lot of business people. I don't think when business people are entering into contracts, ADR is something that's top of mind. In America, for example, I think only 1% of cases go to trial. I mean, so they've already popularized that mechanism of addressing any disputes. So I think what we need here is an aggressive promotion and sensitization across the whole commercial sphere to encourage all spheres where all parties come together into any contractual arrangement to know that there is a mechanism for that. So I think even in Uganda alone, forgetting about investors coming into the country, just looking at the potential to unlock the capital which is stuck in the legal system, that is a huge dividend to promoting ADR in the country, to strengthening all the necessary institutional mechanisms that are required. And disputes don't start only in business. They start between individuals, they start within families, they start within institutions and organizations. So we can even take the popularization of this right down to schools. I mean, we teach our children, those of us who are parents, how to resolve conflicts in a home. Sit down, talk, make your case, you make your case. We as parents sit as arbiters to that kind of dispute in our homes. Now, it's the same framework that we can use to expand the spheres through which we can popularize these mechanisms And of course, the eventual output is less on the economy, less in capital being tied up, less stress on the legal system that can never have sufficient personnel to deal with all these cases. And eventually there's an internal efficiency dynamic that takes place. And then, of course, the dividend at the end is people will look at us as an attractive space to invest. Local businesses will look at it, will look at contracts and agreements as something that they can enter because they've priced the risk as well, without even going out there. So I really salute this initiative and encourage us to keep pushing forward with this agenda.
Well, thank you, Andrew. I would like to open up. We have about 5 or 6 minutes before I close the session, and I'd like to open up the session to comments. I think our presenters have given us an excellent overview of the issue that we are dealing with. How do we promote our seats? How do we get safe domestic seats right across our jurisdiction, right across our region? We've had best practices from Rwanda. We've heard about the initiatives we're taking in Uganda. We've heard about some of the exciting and innovative steps being taken in Kenya. And we've heard from a person who's actually at the sharp end of who deals with the investors who are coming in and who's dealing with the kind of risks that the investors are most concerned about. So I open it up. I don't know whether we have any comments and or questions to our distinguished panelists. Or are you all waiting for lunch? Am I standing between you and lunch? I know it's lunchtime. Milton?
Thank you, Senior Counsel. Thank you, distinguished discussants. Senior Counsel, I asked a question earlier on in the other session, but when there was no hand, so I thought I should take opportunity. Thank you very much for the discussions regarding these investments and making our domestic arbitration strong to encourage investments. My question is actually, it can cut across to all of them. What is our policy or criteria for selecting which investors we want to come and invest in our country? We are discussing what we are doing internally to strengthen capacity, to bring certainty when it comes to dispute resolution that the investors can trust. And that is perfectly okay. But also, I know, for example, there are some presidential initiatives to bring investors, to attract them. So do we have a policy that is guiding us? What kind of investors are we attracting? It's unfortunate we've also heard about some stories where some so-called investors come into the country, get land to invest, and there's no investment made after so many years. I feel that this can also have a negative impact in promoting our destinations as proper investment destinations. On the other hand, if we have a policy or criteria and we attract the right investors, those investors have their roundtable discussions, they have their own clubs. One will promote our destination to another, and that way we'll be able to get more investors coming and credible ones. Thank you.
Thank you, Milton. Mr. Milton Ochen, thank you for your intervention. And I'll ask Peter to warm up to answer that question as I wait for a second intervention. Do we have a second intervention? Okay. Peter, would you like to start off with that question?
Yeah, I'll give it a shot. So we are promoting investment in all directions, and we are being guided at high level in terms of the focus to propel the country into a middle-income country. So with the wisdom of His Excellency the President through the Ministry of Finance, we have a very clear strategy on how we'll progress to that direction of the 500 billion mark. In that regard, so we look across all the sectors that we have very much attention. I highly very, very high attention to agro-industrialization, and here I'm speaking of value addition. We don't segregate in terms of the origin of investment, but what we are very deliberate around is your technology, is your capital. So in the investment code, this is already telling us that have a minimum amount of $250,000, and if you're local, have $50,000. So we need, of course, also a timeline on where we are saying, you told us at the beginning, at the time of licensing, you will deploy this investment in this long. I told you the frustration before has been the delays in the ecosystem of government to ensure that we are providing fairly a facilitation arm that enables that to happen. But where we have been lacking is in terms of follow-up. Year one, what has happened? They have only done landfill. Year two, we have not attended, maybe because of lack of funding, because of ABCD. Year three, so when you go back to year five and say, look, I'm withdrawing this land, it becomes a point of dispute. And now, as my brother was saying, that's not fair to a country or an investor where we are saying we are going to push and unlock investment. So a lot of capital gets stuck there. We are trying as much as possible now to use digitization to lead the way as Uganda Investment Authority. Very soon we shall be launching the very first integrated system that you can click and it tells you the status of licensed investors as we speak now. And at the click of a button, I will also be able at any airport I'm in the world to tell me where my team is and what it is doing as far as monitoring and evaluation is concerned. And it will tell me how many land disputes are happening in which locality. We are working very closely to bring it home with the local economic development investment committees. I'm sure you have heard through the Ministry of Local Government that for us to localize the investment agenda, we are working very closely with the local government and through the district investment committees. And we are ensuring at that point that we are inducting the leadership at the district investment committees, at the district level, these things that we are talking about, so that there is alignment in terms of execution of this agenda, but also as we go to foreign investors, they then are prepared on what to expect on the ground. And before we know it, this should be working seamlessly. So we believe that such an intervention will be a good recipient to these efforts that we are doing. Thank you very much.
Thank you, Peter. I would like Claire to perhaps also give some remarks on the best practices you adopted to ensure that you are able to monitor the investment coming in, to monitor the concerns that they have, and to ensure that you don't have quack investors. I think that was Milton's principal concern. Even as we talk about creating safe seats, we also don't want quack investors coming in. What was your experience in Rwanda? And as you do so, maybe you can also make your final remarks. Thank you.
Thank you, moderator. I think, first of all, it started with what the country wants to achieve. So in order to get good quality investors, first of all, what does the country want to achieve? So we had national plans, what we call the Vision 2020. We had annual plans, 3-year midterm plans. And so in those plans, we identified what we understood the country needed and the country was competitive in. And so we identified those sectors, and then we identified specific investments under those sectors, both for the immediate needs, but also for the future. We also saw things like technology, artificial intelligence, electric mobility. How do you bring all of those that are long-term investments, but also we think the country wants to drive towards that direction. And so we combined both the immediate, but also the future outlook of where the country wanted to go, and then attracted investors in those areas. We did, basic business plans for them to show that there was opportunity there, but also to really prepare for the investors that we wanted to invest, for them to make a decision easily, because we've done some of the work in assessing the opportunity for them and doing some of the basic business plans. So that was one. But obviously, there are two types of investors that we had. One, those that just came and invested. They saw the opportunity, they assessed the market, and they risked their money there. But we were very careful about where we actually deployed our resources to attract investors, and there we're very selective. So if we're going to either give you a special package of incentives, or we're going to do detailed business plans, to really show you and to de-risk your investment appetite, we were very selective about which ones we chose to do that. And those had to be investors that we thought would transform the economy, would either change or move the needle in a particular industry, or would bring a very specific type of investments. And, for example, bringing Carnegie Mellon University to start an African campus, or doing a vaccine manufacturing, industry. We even tried device manufacturing, things that we thought were transformational. We did a lot of incentives and a lot of work for them to do that. Sometimes we even gave off-take agreements. We created demand or stimulated demand because we wanted that specific investor. So for those kinds that we reached out to, invested in, we're very selective. We gave them, again, very similar to what Peter was saying. We gave them performance KPIs. We agreed on timelines. We agreed on what success looks like. And if they didn't do that, if they fell short of that, and there was no clear reasons or justifiable reasons, we actually, we held them accountable. So accountability was important. We either took back the investments, or later on we started putting performance bonds, depending on how good it was. Would recall the performance bonds if they didn't meet those requirements. So we really increased accountability because we're investing a lot in those type of investors. While the ones who came on their own and took the risk and invested, that was a different type of investor from the one that we're investing in. So all of that, I think, accountability and holding investors accountable, but also making sure that they're investing and you're investing in areas that you've already done research, will actually move the needle and transform the economy. That was very important, and that really helped us be successful in the type of investors we chose. Thank you.
Thank you very much, Claire. The conversation.
And maybe just for closing remarks, I'm really, really pleased that I was invited to be part of this discussion. Even though I was talking so much about my previous job with the Rwanda Development Board, obviously in sports is one of the industries that has a lot of contracting. When I look at the contracts that come through our organization, whether it's getting new teams or players or broadcasting rights, I think this is a relevant topic for me, even in this budding, business of sports in the continent. And I think this is a very relevant topic for that as well. So I'm very pleased to be part of this discussion, and thank you for having me.
Thank you, Claire, for making the time. We've really enjoyed your interventions and your advice and your experience. You've shared your experience with us, and we wish you very well in your new role. I would like to end with Claire. She has taken us up to the summit. Indeed, my distinguished panelists as well have shared a wealth of experience, have given us insights into how we can make our seat safe. Ultimately, what we are trying to do is to ensure that we have a prosperous country, a country that is able to attract business, a country that is able to attract business that will give our children jobs, that will give the government taxes to build better infrastructure and so on. So very useful discussion. Thank you very much, my distinguished panelists. Perhaps we can give them a round of applause. Thank you. And thank you, participants, for your attention. You may clap for yourselves. Thank you, Ochen. You can also clap for the moderator.
Senior Counsel, thank you very much. Our dear panelists, we have some gifts for you. And I would welcome Justice Mubiru to help us with the handover of the gifts and take a photo with you. So kindly, if you could be upstanding to receive your gifts. We are very appreciative of the nuggets that you have shared with us. We will start with Claire. Unfortunately, your gift will remain with us, but we will give it in honoraria as the rest receive it. Mr. Gasira, thank you very much.
The next one is Mr. Peter Muramira.
Mr. Peter, that's Juguna, David, Mr. Muramira, excuse my pronunciation. And then finally, but not least, our moderator, Mr. Adrico, Senior Counsel. Thank you very much. A round of applause, please. Let's take a photo with all of you and Justice Mubiru. Have we earned our lunch? No, we haven't. We proceed. There's no response. Have we earned our lunch? Guys, have we earned our lunch? Okay. So lunch is being served at, apologies, downstairs. I don't know where downstairs is. There must be a name to that restaurant. Okay. Lunch is being served downstairs, wherever that is. For the Muslims today, our prayer room will still be Aswa. We can convene there for our prayers. Enjoy your lunch. Bon appetit. See you in the next 45 minutes for the next sessions. Asanteni sana.
Some attention for clarity. The rooms where we're going to have our lunch the room where we're going to have our lunch is Amber Restaurant. We'll be having a few people there who will guide you in case you don't know where Amber Restaurant is. Thank you.
In Uganda, they're the backbone of Uganda's economy, constituting over 80% of the private sector. SMEs generate approximately 80% of the manufactured output, contributing to around 20% of the national GDP. They employ 2.5 million people in Uganda. That is between 88% to 90% of the private sector. We cannot have a conversation on ADR without looking to its impact on SMEs. So I'm going to start by inviting Mr. Alike to make his presentation to us, following which we shall have a conversation with the panel, and then I'll invite some questions from you. So thank you. Philip, over to you.
Thank you very much indeed, Nora. I do have a bit of an echo here, which I'm finding difficult to deal with because I'm speaking and I'm hearing myself again. I don't know if that's something that technical people can resolve. The other issue is I have this PowerPoint presentation, which I should like to make, and I'm not sure that you can see it, and I'm not sure that I have the technical capability to share my screen. I'm happy if somebody wants to take and I will go through the slides. If they want to do this remotely, I'm happy to indicate that the page should be turned.
Okay, so with regards to sound, on our side, there's no echo, so it's probably just on your side. When it comes to, as far as the presentation is concerned,
Yes.
I don't know, the technical team, are you? You can, Philip, I'm told that you can share your screen. Yes? He can share his screen.
I'm not sure that I have the technical capability to share my screen.
Okay. Let me see if I can.
Sharing my screen.
I don't understand what this means. Philip, kindly bear with us while I reach the technical team comes to help us out. So, Philip, the technical team is trying to figure out how to do this.
I'm also trying to share. Yeah. If we can. Have you got it now?
We see, yes.
So the question is how I expand. Do you see?
We do. I don't know if you can read. Can you see?
Yes, I can screen.
Is it big enough for the team?
Yeah, it's for me.
Yes?
It is. Everyone else?
Okay, Philip, you can go right ahead.
Yeah. The only is the question is the feedback.
There's no feedback on our side.
So, yeah. Good afternoon, distinguished judges, colleagues, attendees. Thank you very much indeed for coming and being present today to share in this really, really interesting discussion about SMEs. I hope that you leave the end of this particular session having heard from my colleagues and myself and feel that much better equipped to deal with what is described in the flyer for this particular session as domestic arbitration. But I think you'll find by the end of this that there isn't actually any such thing anymore as domestic arbitration because of the proliferation of the way that we enter into commercial contracts cross-border. With a touch of your phone, you can make a contract anywhere in the world. So domestic arbitration, I think, is something of a misnomer now. But in any case, I'm hoping that you'll leave with some valuable lessons. So what I am going to do is very quickly, I'm going to sketch out some aspects of the presentation. Essentially, the thesis is that we need to have a joined up, cohesive system for dealing with the prorogation of jurisdiction and choice of law. And you might think, well, how is that relevant to SMEs and arbitration? And I hope by the end of this discussion, it will become apparent to you. To the 3 points, the 3 areas, the focus of this presentation is going to be the vision, the obstacle to achieving the vision, and a proposed solution. So Nora has already sketched out the importance of SMEs and GDP contribution to Africa, so I won't spend time about that. But worth bearing in mind, Africa Continental Free Trade Agreement, technology integration, looking at cross-border transactions. The purpose of having a joined up, a cohesive system is, again, freedom, security, and justice. The idea that we need to bring about a system across border that hangs together. And again, I hope this will make more sense as we progress through these slides. I wanted to illustrate the point using a particular case. This is a decision of the Honorable Justice Paul Allen Nshimye in the Huvas Investment against Equity Bank Uganda Limited case, which was a case, ordinary case, you might say, involving a customer who had taken a loan using the Easy Stock Finance loan from Equity Bank. The loan agreement provided for the laws of Kenya to apply, and jurisdiction was prorogated in a way to arbitration. It made a provision for arbitration, but also the laws, the Kenya High Court, and we'll come to it in a moment. Along with the loan agreement, in parallel with the loan agreement, was a personal guarantee and a key facts document. And that document provided for the laws of Uganda and the High Court of Uganda. The particular clause involved is here set out, and it provided for the borrower to irrevocably submit to the jurisdiction of the Kenyan courts. It provides that the submission to jurisdiction of the borrower shall not prevent proceedings being brought in any other competent court. And then it referred the dispute to arbitration. And then at the very end, and these are the parts that are highlighted, it provided that neither party shall be entitled to commence or maintain an action in a court of law upon any matter in dispute until such matter shall have been submitted and determined as hereinbefore provided, and then only for the enforcement of the arbitration award. And so anyone looking at this document, particularly those who are less familiar with arbitration, might think, well, look, I always thought and understood that you either had an arbitration clause or you had a court jurisdiction clause. How do you reconcile the two? This case was particularly interesting because what the bank was contending was that because the agreement had been signed in Mbarara, that the Ugandan High Court applied. And the counsel for the bank was saying, well, there is this guarantee that provides for Ugandan law, and it was signed in Uganda, therefore it should be a Ugandan High Court. And in my respectful submission, the learned judge got this absolutely right. He said, actually, the loan agreement is separable from the guarantee. Deal with the loan agreement first, and then you deal with the guarantee, depending on the outcome of the loan agreement and the liability under that primary agreement. And then you have your resolution. It raised an interesting point because, of course, the question then arises, why did they consider that they should be going to Mbarara in the first place? And we'll come on to see just further down how legislation in Uganda, in particular, the Electronic Transactions Act, provides for the formation of contracts at the place where there's an acceptance. But I go back here because I think it's really important to just look at the various contentions. So I've summarized what Counsel for Equity was saying, place of contract Mbarara. Not sure what the basis of the assertion was. It might have been the Electronic Transactions Act. And I've also mentioned what the judge decided. Now, when one is presented with a jurisdiction choice of law, I mean, you can just imagine what might have happened. So in Uganda, what happens in the High Court is the debtor, customer, applied for a stay under Section 5 of the Arbitration and Conciliation Act. The bank was saying, no, we should be carrying on. It would have been possible for the customer to have gone to the High Court in Kenya, which is the supervising court of an arbitration jurisdiction clause, and asked the Kenya High Court to issue a anti-suit injunction to essentially to preclude the bank from continuing with the High Court proceedings in Uganda. And that creates this very interesting dimension that you find now with cross-border claims, where unless you have clearly stipulated in which court or where the disputes are supposed to be resolved and how they're supposed to be resolved. So it's two things. It's one, jurisdiction in terms of the physical location, and it's also the particular forum, so high court or arbitration, then potentially you can run into all kinds of difficulties. And this is really important for small businesses that never really stop to think about the consequences of what it is that they're doing, what the provisions that they have in their contracts. And so I come back to the Electronic Transactions Act, which I referred to previously, and you'll see here at section 14, subsection 2, a contract by means of a data message is concluded at the time, when, and the place where acceptance of the offer is received by the person making the offer. And you think about using your phone to order something on Amazon, or to buy something online, or to buy something from Tanzania, or whatever it is, using well, if you're using your computer, fine, but if you're using your handheld mobile phone, where is that contract made? Imagine if you're in Malaysia, or in Australia, or in Botswana, and you accept an offer that's made. Does the law of Botswana or Malaysia apply? It's conceivable that that would be the case, because that is what the legislation seems to provide for. And when you have time afterwards, please go back and look at, I think it's section 33 of the Electronic Transaction Act, which actually places no territorial restriction on the particular provisions of this act, so that in fact, under the law of Uganda, it's conceivable and arguable that a contract that is made using your mobile phone in a different place, if accepted there, would mean that the law of that particular place might apply. Now, I'm just coming on to a slightly more difficult, but also equally important provision, which goes hand in hand with this question about governing law and jurisdiction. And those that are familiar with international arbitration, and I say international arbitration, will know that there are potentially 4 or more kinds of law that will apply in an arbitration, and you've got to be absolutely familiar with them. There's the law of the forum, of course, which is the law of the dispute. So if you're in an arbitration in Uganda, it would be, of course, the place of the dispute, which is Uganda, different from the lex arbitri, and I'll come and explain the difference. That's the last one. But there's the law of the matrix agreement. So the contract itself, as in the easy loan form contract, provided for the law of Kenya. So the matrix contract, the substantive contract, would be the contract of Kenya. But we also know that arbitration agreements in a substantive contract are separable. Separability is one of the key hallmarks of arbitration. So you would have, and potentially you could have, a separate law applying to the arbitration agreement. They don't always go hand in hand. And in fact, you see this quite often, where you'll have a Ugandan dispute between an investor and a domestic party, and they'll decide to go to Paris, London, wherever, and they will provide for the law of English law maybe to apply to the arbitration agreement. You'll then have potentially a fourth law, which is the law of the arbitral process, which is usually the law of the seat. So you'll often find that the arbitration agreement and the law of the arbitral process, the curial law or the lex arbitri, are the same. That's more common. Important to understand all of those things, because again, when you're dealing with providing for governing law as an SME, you'll want to understand exactly what the consequences are. I just very quickly here, you have the Uganda Arbitration and Conciliation Act and the Kenya Section 29 of the Kenya Arbitration Act, just comparing them. The writing here in red is in fact the Ugandan legislation, and it shows you that they are substantially similar. This is important because, of course, one needs to recognize that the Ugandan law follows the ancestral model law, and most international legal jurisdictions, at least modern commercial ones, follow the ancestral model law. Now, I'm going to now come on very quickly to a solution. One of the things that I think is really, really important for us to get clear and to understand is that where you have a choice of law and you actually elect or choose the choice of law, tell me if I'm going on too long, please, then you will find that there is no real problem because the choice is expressed and it's clear. The problem really comes in when you don't think about it and there is no provision for it. when you're exchanging contracts. What you really want to avoid as an SME is getting involved in a dispute with somebody in a different country or in a place, or using a system with which you're entirely unfamiliar. And what I'm suggesting that we do, and I think this is something that we in Uganda, in East Africa, in Africa should be thinking about, is following the European example of regulating the laws that apply. And the way that the Europeans have done it is they've divided it into what is called Rome 1, which are the rules for determining what law applies where you have a contractual obligation, and Rome 2, which we'll come on to a minute, which deals with non-contractual obligations. Now, you may say also, how does this necessarily help? Well, I've been involved in many arbitrations in Uganda, in fact, just last year, where the question of prorogation of jurisdiction under Brussels, which we'll deal with, and also Rome 1 was important. So if you are aspiring as an arbitrator, if you really want to understand arbitration, it's actually important that you understand how these provisions work. But that's not really the point of this particular presentation. The point of this presentation is to say that the way that the Europeans have organized the rules for determining the law applicable to any dispute is so good. When the British left the European Union at Brexit, they were absolutely determined to try to preserve these rules. And Britain succeeded in adopting and domesticating Rome 1 and Rome 2 into English law, notwithstanding that they had now come out of the European Union. But they weren't able to domesticate Brussels 1 because that required the European member states to approve. And the European member states were so angry at Britain, they weren't going to give them anything. They weren't going to make that an easy ride. We on the continent, thinking about fostering cohesion, fostering commerce and business, do not need to reinvent the wheel. We need to look at the models and examples that have succeeded. Europe is particularly good because, of course, we know Europe is not a federation of states. It may be a confederation of separate sovereign states. It's unlike, the UAE or, for example, the United States of America or Nigeria. So Europe has had to grapple with this real problem of bringing about cohesion. So I'm not going to actually go into the detail of the particular rules, other than to say that it sets out the way that you decide what law applies. Now, there is one important exception that I need to bring to your attention, which is that the arbitration is excluded from this. And therefore you think to yourself, well, why are we looking at this if arbitration is excluded? It's important because, as in the case that was before the judge on the Equity Bank case, before you invoke or when you're thinking about engaging the arbitration agreement, you have to know where it is that your dispute is going to be determined. And you'll remember that there was the choice of either going to Kenya for an anti-suit injunction or being in Uganda, as happened, asking for a stay. Which court has precedence? Which court was the proper forum? That question is not answered by the arbitration agreement. There's an anterior question, which is where you go. And that question is resolved by these particular rules, which is why it is so critical as underpinning arbitration. And so arbitration is contractual. This contractual provision would apply. In terms of non-contractual obligations, no need for me to spend time on this, but it does exactly the same, provides exactly the same rules for determining non-contractual obligations. So if you have trust issues, if you have tort issues, personal injury issues, all of these issues would be dealt with by the non-contractual obligations. Environmental claims, all of these rules determine. I mean, if you have, for example, there was a leak, God forbid, on Lake Albert, and oil escaped and goes to Congo. Is it a Congo court? Is it a Uganda court? Where is the damage sustained? These are all the sorts of things that are relevant and that we need to think about. And finally, I'm just going to refer to the Brussels recast. Now, the Brussels recast actually deals with the jurisdiction. And really critically important to get in one's mind the difference between the applicable law and jurisdiction. Applicable law says which law applies. So you might say that under Kenyan law, reading Kenyan law, this is what it says about jurisdiction. But the Brussels recast, which is the European rules, says in any particular situation, if you have this kind of claim, it goes to that court. It goes to the court of the claimant, or it goes to the court of the respondent, or it goes to the court where the injury took place. Those are the critical provisions. And so that is absolutely important. Again, arbitration is excluded for the simple reason that arbitration tells you where to go. So in that sense, the arbitration exclusion is not particularly problematic. However, I come back to the point that I made before in relation to the Rome 1, which is that it is really, really important that you prorogate jurisdiction to a particular court so that in the event there is a dispute, you know which court you're going to. In other words, as between Uganda and between Kenya, in that particular example, you would wish to know which court has the upper hand. So if I can just quickly go back to the jurisdiction clause in the Easy Stock Finance Agreement, you'll see here that it's, although it provides for arbitration, it also provides for an irrevocable submission to the jurisdiction of the Kenyan courts. And in my respectful submission, that is an excellent a jurisdiction clause, because it shows that actually, if there is a dispute in relation to the loan agreement, that loan agreement and the substance of it, the applicable law and everything else, should have been determined in the courts of Kenya rather than in the courts of Uganda. So an additional reason that the judge might have declined that case might have been on the basis that the Kenyan courts were competent to deal with that particular dispute. So those are the rules that I'm proposing. I say where there's no need to reinvent the wheel. Go to the European rules, look at those rules as an example. If we follow that example, then we will be in a much better position to work out this cohesive system. So, ladies and gentlemen, I say for God, my country, my region, and my continent, I think we should follow the Europeans, not because they're Europeans, but because they have a tried and tested system that works brilliantly and would avoid the sorts of problems that SMEs are going to increasingly encounter, and indeed big institutions encounter, if they make no provision for governing law, first and foremost, and jurisdiction, where your disputes are resolved. And all of this is absolutely critical to reinforcing, underpinning, and supervising the arbitration process. Thank you very much indeed.
Thank you so much, Philip. A hand clap for Philip, ladies and gentlemen. I think, I don't know what everyone else's takeaway is, but my takeaway from Philip's presentation is the essence of properly drafting arbitration clauses. We were speaking earlier about simply adopting, copying and pasting arbitration clauses without appreciating the impact. I think there was someone who gave an example today about a dispute whose value was 20 million, and the clause provided for, I don't know if it was ICC or Paris. Now, I don't know if you know, but to file, just to file your dispute, just to file it in Paris, it's 5,000 euros. So imagine you have a claim of 20 million, but the mechanism that you have chosen and the institution that you have chosen charges you more than what you're claiming for that dispute. So when we're drafting, we need to be mindful of the disputes that we might encounter and the parties with whom these agreements are between. So before I go forward, Anne, is there anything else you would like to add to Philip's presentation?
Thank you, Nora. Thank you, Philip. Good afternoon. I would like to add something small, an example from our courts here again, on the danger of not providing adequately for choice of law. And there's a case that was recently decided in our courts, the case of Kampala International University and Housing Finance Bank, nearly same facts. KIU goes to Kenya and gets a loan from Housing Finance Kenya to construct something in Kenya, to construct a university in Kenya. And the arbitration clause was very interesting. It provided for arbitration for any dispute arising out of the loan agreement. And then it provided for court for any dispute arising out of guarantees. So there are two different sets of laws. So when it went before the arbitrator, he ruled in favor of the bank, and then somehow in the middle, the loan was transferred from Housing Finance Kenya to Housing Finance Uganda, making things more complicated. So the arbitrator finds in favor of Housing Finance, finds majorly in favor of Housing Finance, therefore the issue of interest, where he said that Housing Finance had charged exorbitantly. So there was a set-off. And then it went before the Kenyan courts as the seat. It went before the Kenyan courts as the seat of the arbitration for enforcement, and the enforcement order was given. So pursuant to the New York Convention, which provides for enforcement of international awards, it came to Uganda for enforcement in Uganda under Article 5 of the New York Convention. And the judge said the argument of KIU was that the Ugandan courts do not have jurisdiction. The jurisdiction lies with the seat. Yeah. And the judge said that we are bound by Article 5 of the New York Convention, which is very specific on the grounds for refusal of enforcement. Very specific. And he said that in this case, he was not bound by the decision of the Kenyan court, but rather he was bound by the decision of the arbitrator. And he saw no need to refuse to enforce. So we have conflict. The judge in Kenya has said one thing, the judge in Uganda has said one thing. It is now on appeal. And we wait to see what the Court of Appeal will say. But it's a clear-cut example of what happens when you do not properly draft or don't put a lot of thought in the drafting of your arbitration clause as an SME. And then you have conflicting agreement, you have conflicting judgments, same as the equity case that Philip was talking about. When you look at that case carefully, it may look pathological on the face of it, the arbitration agreement that Philip was talking about, because part of it provides that arbitration shall govern any dispute, and then the other part says, however, they will go to court if the dispute arises from the arbitration. Sounds pathological. But our court said no, that the intent of the parties was to arbitrate. And they upheld the arbitration clause. A civil suit had been filed in the case that Philip had said, and that suit was dismissed and the parties were sent back to arbitration. So if you as an SME are not very careful when you're drafting your arbitration clause, you will face such problems, and it will take a long time for you to know exactly which arena is supposed to give you the justice. That's what I wanted to add. Thank you, Nora.
Thank you. And Olivia?
Maybe just to say, she's really on the technical she's spoken. Good afternoon, ladies and gentlemen. I think the issue of also the cost, so you can imagine the two examples, how expensive it was for the parties, especially if it's an SME. So when the clause is poorly drafted and therefore causes issues in implementation, the issue of costs arises. So you find that you have a challenge that parties will spend a lot more money trying to iron out the intricacies with the clause, trying to fight over the different aspects of the clause that are unclear, yet it could have been much cheaper had the parties taken care of that at the time of drafting. Thank you.
Yeah. I think our takeaway is drafting. I'm sure the judges of the High Court have seen unique clauses when it comes to arbitration. You'll always find a clause that says the parties will go to arbitration. If arbitration fails, they will go to the court. I've seen that one a million times. Or you provide for a clause for getting the parties that are involved in that agreement, and forgetting that maybe you will want to claim for interest, and you will make a seat that doesn't recognize interest, or a jurisdiction that doesn't recognize interest as your seat. So then you cannot claim for interest. We have countries that do not believe in interest, so we need to be careful when we are drafting. If in doubt, simply use a model clause, ladies and gentlemen. If in doubt, don't be creative. Just use a model clause. All right. So let me go straight to the panels. The ladies have all had a chance to speak. So, Doctor, I am coming straight to you. You are the ED of UMA. You have several members. Now, your members often complain about the time and cost of litigation. What would it take for your members to fully pivot to arbitration?
Thank you very much for that very bitter question. But I want to thank you for giving me an opportunity to talk to people who are cladded in black and navy blue without saying my Lord first. So, and for once, when I'm guaranteed that what I'm going to say will not be used against me. So I have the opportunity and I will always be grateful for this. Manufacturers belong to the business community. Business community as a doctrine has got its ways and means of executing their businesses. Now, one of the tenets down there is that don't spend a coin. The second one is time is money. The third one, the person in front of you is your enemy, is your competitor. Now, what does that tell you? It tells you that from the word go, you are enshrined in an environment which is full of injustice. Now, if it is full of injustice, for you to survive there, what does it mean? That you have got to do acts of injustice and acts of justice. When it comes to the way disputes in that unjust environment, by the time they manifest themselves, the disputes, to the level of coming for litigation, there is a lot that you people, I would presume, sometimes you don't know. What does it mean for ADR, for the people in the business community? It manifests three things. Number one, most of the disputes in SMEs are relational in nature. They are relational in nature that either I have started this SME with my wife. How do you separate this, my wife from my business, from the business I'm doing with other ladies? It is so delicate that because of relational underpinning, conflicts and disputes are eminent in the business world. Two, I am going to start a company either with my friend because we're in the street, we finished Makerere, and both of us can't get a job. When one gets a job, I call this double-legging. He's going to put a lot of his effort the other side, and this side, I will suffer alone. What does it mean? I have now to start to find a way of squeezing this person out. And remember, when you are starting an SME, you do not have money. You start from the zero ground, and therefore you do not have the tools that a magistrate or a judge will use when you get conflict. He will say, where is this? You don't have. Where is this? You don't have. You are basically, if you want to measure this, there are two indicators. Indicator number one, trace the percentage of cases that you people have sent away, dismissed. Why? Why do you dismiss cases? Someone comes, you look for logic in it, you can't find it. You look for record, you can't find it. The best you can do to save your time as a magistrate or a judge is to say, please don't waste my time, go. But the day you say go, you are actually seeding more of this problem. Have you ever done research to know what happens to these cases you dismiss? What happens? When you dismiss these people, where do they go? They are content, both parties? Do they come back? Do they go and hang? Or this manifests in another dispute. Number two, how many people come seriously and attend twice, or you call in court for the third time, the complainant is not there? Loss of interest, why? It's because most of the cases that emerge from us, the SMEs, are relational and therefore are most of the time based on whims, not legal sense. What does that tell me? It tells you that in SME disputes, there is a need to open up and start to look facts that serve logic sense, sometimes which do not serve the legal sense. And that's to me where I say, this thing called arbitration, if brought to SMEs, could help us to serve. Then the other thing in civil litigation, there is always a winner. But in real business sense, the law of averages can't allow that it is only me that made everything wrong and bad things. I remember my grandfather, whenever we would conflict, he would say, first, both of you 3 canes, now you start to explain. After explanation, the one that actually wronged more will get 6. Meaning that naturally in human interaction, there is no way that I was the cause of the conflict every other time up to the end. So there is a need to share some sort of this responsibility so that at one moment, the dispute resolution kind of approach identifies, say, Mr. Muhumza, you wronged the other person up to this level. She could have also wronged you up to this level. That, we think, we don't get it from court. If arbitration can give us that, then you know that at least there is some level of a win-win situation or win-lose up to a certain percentage. Now, lastly, as manufacturers, the conflicts we face, or in the business community, they are intra, a worker and a boss. At what level and who should be the arbitrator at this particular time? And when you look at the cost of arbitration, who should be able to pay it? Then we have got suppliers. Most of the cases, especially those from outside, you get people complain, say, I supplied to China, they didn't pay me back. I supplied so and so, these supplies. So in my view, we should go beyond the training of arbitrators. But we include training when we are talking about business strengthening. The courses we offer to do businesses, we inculcate more the legal foundations. I would suggest that one of the resolutions here should be, how do we go to these tertiary institutions that produce business people, entrepreneurs, to enhance courses that would bring in legal foundations, so that by the time I come to court, I know what to present. I come to an arbitrator, I know what to present. So, in my view, the legal fraternity has been so distant from supporting the business community to appreciate the doctrines and foundations of justice. Lastly, I will now pose this question to you, because these are devil's advocate questions. If we are talking about arbitration right now, are the players in the other side of legal civil litigation where there could be some more money willing to let go and these low-down level arbitrations work? I will cite this, and I hope it is not put on camera. There is a procedure of late we have been informed about, that there is some arbitration that takes place that is required as a procedure before you go for civil suit. Do you know what lawyers tell us? That one is useless. They are just creating jobs for retired judges. After all, it has no what? Meaning. Let's go for civil suit immediately. So I am trying to say, we all agree there is a need. But are the other players, the advisors to this person who is enshrined in injustice, environment of injustice, ready to support this approach? That is first devil's advocate question. The second question is, when I am paying right now, I never pay to a judge. You don't pay to a magistrate, you pay to court. And court is no one, it's an institution. No one has ever gone when you are in court and say, okay, I've lost the case, pay me back my fees. No, you paid to court. This is an institution. Now, when it comes to arbitration, and you are a arbitrator, an arbitrator, there is some little cost I pay. What happens when I lose? I am most likely going to keep saying, you. I gave you my money and you made me lose. So these are some of the hypothetical challenges as we bring this doctrine down, we need to think about and think very well. Thank you.
Thank you so much. Sometimes it's embarrassing to be a legal practitioner or have that background, because when he said what he said about what lawyers say about mediation, you know it's true. You know that lawyers have actually said that, and you know that they actually tell their clients, oh, we'll just go, we'll frustrate it, and then we'll go to litigation. I don't know how we are going to combat that one. I don't know what we shall do in the future, because sometimes the problem is not even the parties, sometimes the problem is us, the lawyers. But thank you for highlighting that. Embarrassing as it is, we need to address it. So let me move to you, Olivia. Olivia, how can we bridge the gap between banks and SMEs so that arbitration becomes the preferred means? We know the relationship between banks and SMEs. We know how integral it is. How can we bridge that gap so that arbitration becomes their preferred means of resolving disputes?
Thank you, Nora. I think I'll even start with part of what he talked about in terms of education and capacity building. I think you are hearing the mix-up between arbitration and mediation. So the business community, when they hear arbitration, they understand mediation. That is the way they understand it. So they believe it's a situation where you're going to sit, have a neutral third party help you mediate your dispute, and there will be a win-win situation, which is different from arbitration. So it means that there is, first of all, need for the SMEs to appreciate the different ADR mechanisms, appreciate what it takes to engage in them. And so the banks and SMEs who are their clients, the banks are already probably at a better level because they understand what it is, but then the SMEs need to understand what it is arbitration is about and what are the benefits, which I think everybody in the room knows, but for the SMEs, they may not be in position. So I think that's one of the beginning point. The other would be in terms of once we have gotten the appreciation, there are certain financial disputes that are arbitrable. Not all of them. There are some which may not be arbitrable, but there are some that are arbitrable. So for those that are arbitrable, the banking sector with their customers after the proper education can have arbitration clauses embedded and simple clauses that will not burden the SME, understanding the whole context. He has given us that background. So understanding the context of where the SMEs are coming from, the financial consideration, they don't want to pay anything. They don't want to pay anything. And yet in arbitration, you must pay. You must pay the arbitrator, you must pay legal costs, you must also pay the expenses. So understanding that, clauses that would be more user-friendly for the SME sector. And then for institutions, for example, ICAMEC and other arbitral institutions, to have specialized programs for SMEs in terms of the fees structuring. They could motivate them to adopt arbitration through the institutions by having specialized programs that cater for the SME sector in terms of fees structuring. And I think the Singapore International Arbitration Center has such a program. So it's something that we can, look to and see how we can benchmark. And then the other, I think I would also probably recommend that whilst we're dealing with arbitration, we could also have a mechanism where some of those clauses allow for mediation, to allow the parties an opportunity to consider having to mediate before they go into the full-blown arbitration. And finally, I think utilization of technology would be helpful in terms of reducing the costs. Travel costs, moving witnesses here and there, documentation. So if the technology is adopted, it could also enable a cheaper cost management, to bring up cost management element in terms of the arbitral process. So in view of that, I think those are some of the points I would highlight. Thank you.
Thank you so much, Olivia. I think I can't agree with you more. There needs to be, it can never be a one-size-fits-all. What works for the banks cannot necessarily work for the SMEs. What works for the big corporations cannot work for the small ones. So we need to appreciate that. And I'll be happy to tell Dr. Ezra that the Center and Private Sector Foundation are actually developing a program for mediating SMA disputes. So hopefully we can roll that out, and that can sort of give you some comfort going forward in terms of resolving disputes. So as we move ahead, so Anne, as far as SMEs are concerned, if I were to ask you to draft, say, one incentive, whether tax, regulatory, or judicial, to make SMEs prefer arbitration, what would it be?
Thank you, Nora. Dr. Ezra has spoken about, he's spoken his heart out about SMEs and their concerns. And he said they need to preserve relations, they don't want to spend a coin, and they want to save time. So the incentive I would give to SMEs, for example, about not spending a coin, is advocating for something that was spoken about this morning, and that is third-party funding. So under third-party funding, you get an independent person to fund the entire arbitration process. In Uganda, as it was mentioned, it is still illegal because of our laws that don't allow champati and maintenance. Because under these agreements of third-party funding, the third-party funder is entitled to a percentage of whatever proceeds will come or costs that will come from the dispute. So we would encourage for third-party funding to be made legal in Uganda. Nigeria made it legal. They amended the Arbitration Act and all their laws. And we have guidelines. The Chartered Institute of Arbitrators issued guidelines to guide third-party funding because they realized that it is the future. The SMEs don't have money and yet they have disputes. So the incentive would be third-party funding. Another incentive to save time would be to adopt documents-only arbitration. So the parties can say, this dispute is going to be resolved through only documents. The arbitrator will review documents and render an award. There is no need to call 10 witnesses on each side and have 1 year of cross-examination. So the parties would incentivize and say, let's have a documents-only arbitration. Both parties present their cases through documents, and then an award would be rendered based on those documents. And then to save time, we would push for expedited arbitration. This is arbitration that is carried out very quickly. The parties agree that within a stipulated period of time, this arbitration shall be carried out. Again, the Chartered Institute of Arbitrators released guidelines to guide on expedited arbitration. The ICC has guidelines to guide on expedited arbitration, as well as the UNCITRAL rules. they have guidelines to guide on expedited arbitration. And most of these rules limit expedited arbitration to a certain threshold of a dispute commercially. But if the parties agree, even if it is above the threshold in the rules, then they can adopt the expedited arbitration. It's, the parties are given a very short time within which to file their documents. Between 15 to 28 days, they should have filed everything before the arbitrator. And the arbitrator should, in 60 days, have rendered a decision. How does this save money? It is way cheaper. It is way cheaper to have an expedited arbitration. The fees of the arbitrator are way cheaper. So I believe that the SMEs will save time, will save costs, and then about saving relationship, finally. This is not an incentive, but it's a guide to what Dr. Ezra said. Saving relation, how do SMEs save relations? We could have a multi-tiered clause, and Olivia spoke about it. About 2 years ago, the ICC carried out a survey and found out that arbitration is now a last course of ADR. It's no longer the first course, it is the last course of ADR. So we have settlements, we have negotiations, we have mediations, and then when it finally fails, you go to the arbitration, which is final and binding. Dr. Ezra said some of these disputes are based on whims. So really, by the time you finish negotiating and settlement and mediation, all the emotions have died down and you have healed the relationship. Going to our brothers and sisters in the construction industry, they are the ones who have adopted the multi-tiered clause very well. So if negotiation can't work, then depending on the contract, for example, if it's a FIDIC type of contract, it provides for the engineer. If the parties fail to agree, then the engineer, they will go before the engineer for a determination. If the engineer cannot give them a determination, then they will go for adjudication. Now, before they opt for arbitration, they will have to issue a notice of dissatisfaction. Now, there's a stipulated timeline within which to issue the notice of dissatisfaction. But that doesn't mean that when the timeline expires, you go for arbitration. No. When the timeline expires for the notice of dissatisfaction, you first have a conversation within a stipulated timeline. If that conversation still fails, that is when you opt for arbitration. And research has shown from leading research institutions like the King's College University of London that there are a very few percentage of cases that will proceed to arbitration. Most of them will be resolved at the lower tiers. That is in the construction sector, especially adjudication. So I would advise, as we're drafting, we draft and have arbitration as a last course of ADR. After having exhausted negotiation, mediation, then we will do the arbitration. But I believe that at that point, the SMEs of Dr. Ezra would have finally sorted out all their differences. Thank you.
Thank you so much, Anne. I am being told that we only have 5 minutes. We started late, so I'm being told we only have 5 minutes. We've taken 15 minutes of the next panel. So I'm going to ask the audience first if you have any questions for our presenters before I ask them to make their final remarks. Do we have any questions in the audience? Yes, please. Can we have the mic taken? Okay, so one hand. Do we have any other questions? Patson, okay. Any other ones? Okay. So please give us your name, your question, and who you would like to answer your question.
My name is Damarika Taire. My question goes to generally touches, because everybody who has presented have talked about these issues. So I will give my comments. First of all, we are talking about lawyers misguiding the litigants or the parties. It all goes to lack of information from the people we are trying to protect, the SMEs. They don't have enough information concerning on the alternative dispute resolution. So as people who are in this system, I would recommend that we work so hard to make sure that we popularize ADR to the lawyers themselves to know that it is the way to go. They can resolve disputes using ADR, and again, remain as lawyers, and again, how can they earn from such ways of dispute resolution? And then the parties to be empowered with enough information to know that they can have their issues actually resolved through ADR, what options are available for them, what is that court-annexed mediation that lawyers are telling them that is just a process where you can just pass through and then we go back for, for litigation. What was the purpose of the system putting such a mechanism in place? Once parties have all that information, they will not be misguided by the lawyers or any other person telling them that this is not going to work. They'll be able to make informed decisions.
Okay, thank you. You have a question? Or you were just making a comment?
Madam Anne talked about how these people are supposed to, how they are supposed to have the contracts drafted well and they provide for ABCD. It all goes back to lack of information. The SMEs people, first of all, we must know, most of the business communities, I'm sorry to say, they are not educated to that level. The kind of information they have cannot allow them be able to make such kind of decisions. So it would be important to make sure that we try, by all means, to make sure that information reaches to them and they make well-informed decisions concerning their businesses and how they can resolve their disputes. Thank you so much.
Thank you so much. Patson, can we have the mic go to Patson? Any other questions? Can I assume Patson is the last question? Okay.
Nora, just to answer, I think she asked a question somehow.
Let me just get Patson's question first.
Okay.
Thank you. Mine is really a comment.
Okay, great.
To gentleman from the business community. I'm wondering whether from the SME perspective, whether dispute resolution is considered as part of risk management.
Sorry, Patson, a little louder. We can't hear you.
I wanted to know whether from the SME sector,
yes,
dispute resolution is considered as part of risk management in terms of the business, to appreciate whether, going to court in terms of time spent compared to arbitration, whether it makes, business sense in terms of managing, risks in business, because disputes indeed happen, and what is the best alternative to court where sometimes our court system take longer, and what is the cost in terms of time and money, whether it forms part of your risk matrix in handling business. Yeah.
Okay, thank you. I'm going to request Ezra to respond to that one, but I'll let Anne respond to the earlier comments, but also give your parting shots as you respond to that comment.
Thank you, Nora. Thank you, Damali. So as I respond, I'll give my parting shots, and my parting shots are on capacity building. Damali has said that many people, many SMEs and many lawyers do not have any idea about ADR and the different forms. So I would like to encourage us all to get as much knowledge as we can from the different institutions that train on ADR. As my brother David Njoroge mentioned earlier on, CIAB is the platinum standard for training of ADR practitioners in the world. And Uganda has a chapter that conducts trainings the entire year. So it would be great to see, and it's on different things. We train on mediation, on arbitration, on adjudication, on very many aspects of ADR. So I would encourage everybody in the room, especially the lawyers, and also the SMEs to take part in these in these trainings as offered by CIAB to take part in the webinars to build capacity, and only then shall we understand that it is much cheaper and cost-effective to resolve disputes at mediation or arbitration or adjudication level. Thank you.
Thank you, Anne. Olivia, your parting shots? Or if you have any other comments you want to add?
No, well, I'll just augment her statement on capacity building, and I think we've already talked about that for everybody, especially the business community which we're talking about here today. That obviously the Chartered Institute of Arbitrators would simplify in terms of the kind of trainings that would be applicable specific to the business community to make them better understand. And I know that also as well, ICAMEC does some trainings. So a need to structure trainings that are specifically targeting the business community and break down some of the technical elements of this practice for them to easily understand. But just to encourage the Dr. Mazungumzo that ADR is the way to go. So embrace it, encourage your colleagues in the sector to embrace it, get the necessary training, get your people in the offices to go and train. It's the way to go. Yeah, let's leave the courts for the more complex disputes or for enforcement of the outcomes of the ADR process. Thank you.
Thank you. Philip, parting shots?
Thank you very much indeed, moderator. I just wanted to thank Dr. Ezra, Olivia, and Anne for their comments. I'm really pleased to actually see Eunice Luvalas sitting next to next to Damali and Patson. Their comments and questions really good. My parting shot is this: is that I think we need to start thinking much more constructively about how we deal with ADR and arbitration. And I mean, we were talking about adopting European rules. Some people may say this is completely extraneous and irrelevant. It's not. It's really important. But there's so much more to talk about. I didn't have time to talk about, and Dr. Ezra's point about business and general low-level, and I don't mean that in a pejorative sense. I just mean small value or husband and wife businesses who are small businesses. They need to have a way of resolving their disputes. In financial services, you think about in South Africa, they have the Office of Banking Ombudsman. In Europe, they have the Banking Ombudsman, industry-sponsored, industry-funded institutions for resolving disputes. And actually, if you go back and look at Hansard in Parliament and you see the debates between Eli Karuhanga and Mayanji Nkangi going back in, I think, 2000, something like that, before the Act anyway, late 1990, you'll see that actually the Arbitration and Conciliation Act was intended as a forum for the resolution of disputes within industries, and it was supposed to be relatively inexpensive, but it isn't that. And so now with RAPEX, which has just recently happened, and the restructuring and consolidation within government in Uganda, we should be using CADA now. It should be resurrected as a system, perhaps under the stewardship of a High Court judge, to deal with low-level and smaller disputes in a way that is efficient. We need to think about this whole system again, and rather than just simply reacting to what we have. But thank you very much indeed, moderator. I have more to say, but thank you so much for your attention, for everybody's attention. Thank you.
Thank you, Philip. Ezra, your parting shots and maybe a response to Patson's comments, whether SMEs view ADR as a risk assessment,
I want to put this clear that actually in business community, ADR is needed yesterday. But to answer his question, that do the business community consider, we called it disputes a risk? The answer is yes. And if there is any human entity that detects and hates anything that disrupts their way of being in the world, is the business community. But I want to announce it here that there is a lot of unseen mechanism that is resolving these disputes that you may not formally know. Currently, I think it becomes another research question for the people from universities. what are those percentages of disputes that actually resolved below table? Some of you who are Ugandans, you know. We remember having a person who used to give loans to business people who put in their buildings. And on last minute, you look for him to pay, you don't get him. And what is he targeting? The building. There is a businessman who saved 3 fellow businessmen. You look for him, you don't see him, you go, he gives you money, put on their account. Then he starts to say, where did this guy get money? It's because there is an entity in business who, in your view, is a promoter of justice. He says, no, don't do this to your fellow business person. He gets money, puts on your account, you don't take someone's building because there is some sense of impunity being sensed. So such a kind of within business mechanisms are there which are currently being used to resolve this. So for that matter, it brings me to a comment where I would want slightly to disagree that yes, we may not have to invent the wheel, but we are better off when we learn something from already societies that have advanced in some of these practices. And we try to learn what are the other mechanisms that seem to be emerging domestically. And then we create a blend of the two. So, this again takes me to a third comment, that let's not look at ADR from solving the shortfalls or shortcomings of the conventional civil litigation. The concept I received was telling me the courts are lengthy, they are costly. If they cease to be costly, if they cease to be lengthy, would they solve all these other problems? The answer, in my view, is no. There are certain salient issues that need to be underpinned from the perspective of the free flow of society that we think ADR can solve. For instance, I hear someone say that put documents. Please, there are cases that do not have a single document. What happens to them? They are there, we know. Because we're human beings, we know. Now, if I slapped my wife, there is a document to that effect. Wait, what is that document? But if you sat us down, you may get some evidence as a human being that you can use to you called it what? The first level?
The first
After
tier.
negotiation is what?
Mediation.
Mediation. Something like that. My last short is, at Uganda Manufacturers Association, when we were approached to participate in this, our first concern was, what is it? After trying to understand it, we have made a move already. We are structured in a way that we have got a secretariat that brings together all the manufacturers. Then there is a board of directors who oversee the roles of a secretariat. But we have got a council we call the advisory council. Those who were former chairpersons retire to the council. Now we have engaged that a council adopts a function for mediation in part of their functions. It's not there. I, this morning, actually asked the lawyer to go and amend the resolutions, the articles that make them come together to include the function of ensuring that there is mediation processes within the manufacturing sector. So this, I think, we want to take the lead since we have the money to spend in some of these processes, but we still ask for your technical advice. I thank you.
Thank you so much. Ladies and gentlemen, please join me in thanking the panel for their time and their insightful discussions. Thank you so much, Philip, all the way from the UK. Thank you for taking the time. Thank you, Anne. Thank you, Doctor, and thank you, Olivia. You've got us goats. We don't goats. I'm handing over the goats. Okay, so It's been my honor to moderate. I have learned a lot. Ezra, I hope you and I will partner in pushing forward this process. As a moderator, allow me to close by saying this. We've had several conferences on ADR. I think maybe 2 years ago we had the first, the judiciary hosted, I think, the first ADR summit. I don't remember what it was called, but CIAB hosted a conference last year in November, I think. These conferences are becoming very popular, and every other year we have a new conference. The reality is that we can do these conferences till the cows come home. If we do not start to get our teams, our staff, our colleagues to buy into this, we're just going to always have conferences. So let's take the initiative. If you have not received training, there is CIAB, there is ICAMEC, please get trained. Find out what you can do in this space. It's not just for you to know what ADR is and how good it is for your business, but it's also an opportunity for you to make money, because there's neutrals. If you're a neutral, an arbitrator, a mediator, there is business that comes with having those qualifications. So I encourage you all to get the training, draft proper clauses, and actually apply this so that next time we see it, we're looking at statistics that show that there's an improvement in how we are resolving disputes. And the judges can come and tell us, you know, now there is less disputes coming to the courts. So ladies and gentlemen, thank you. Allow me to pass on these tokens of appreciation to the team that have spoken today. Philip, I will keep your token with me. I hope I can keep it. It depends on what's inside. If it's a goat, I don't think it can last till you come from the UK, but I'll keep Philip's. Olivia, please come receive your token of appreciation. Thank you so much for your time. Doctor, if you'd be so kind. All right, thank you so much, and over to the next team. Oh.
All right, as the photo moment takes place, I want to welcome us to the last occasion of the day, and it's something I'm very passionate about. We are going to have a debate, and I can't wait for what is going to happen. I just want to welcome Ms. Wanjiru to introduce to us the debaters, and then I hope we shall have a great time. Thank you.
Thank you very much. I must say, first of all, it's Wanjiko, the 9 daughters of Mombi from Kenya. We've got the most difficult task. Everyone is tired. This is the last session, but I assure you this is going to be interesting and hopefully very educative. It's a debate, but we are also seeking to inform rather than to have a fight out and see who wins the debate. My name is Wajiko Mugane. And just before I go into introductions, I'm sorry, the particular session, this one is titled, "This House Believes that Arbitration is Best Suited for Climate Change Disputes." And before I move on with introductions, let me just ask, has anybody here, by a show of hands, actually reviewed climate change or has a view? Anybody in favor of arbitration for climate change? Now I know where the lunch went. Anybody who has thought about it? No one has thought about it. All right. We will have a vote at the end once then you've heard what our lovely panel has to say. As you can see, we are an all-woman panel. I am a member of the Chartered Institute of Arbitrators. I am a lawyer and also an investment banker, a lawyer both in Kenya and also in New York many years ago. And I'm a member of the Women in Alternative Dispute Resolution in Kenya, which was founded by one of our panelists. I'll tell you a little bit about her in a moment. I practiced law in my early years before switching to investment banking and selling that business to Standard Chartered Bank, and then returned to the law eventually via ADR, which is why I'm here now and very, very privileged to be your moderator today. So, my first introduction is of Eunice Lumalas. She's going to be our first proposer on this debate. She's a fellow of the Chartered Institute of Arbitrators, a very, very, very senior lawyer. She's a corporate and trial lawyer. So Eunice tends to sit both on ADR and also you don't want to find her in court either. She's Kenya's representative to the International Center for Settlement of International Disputes. And she's a member of multiple international ADR bodies. But she's also the founder and chairperson of Women in ADR, based in Kenya, but with reaching out into the rest of Africa. Our second proposer of this debate is Mariam Nanza Iga. She's a member, yes, sorry, hold on. Yes, Eunice? Oh, you needed to wave and say, that's Eunice, all right. Okay. Nanza Iga. Nanza, maybe you can wave equally, so they know who that is. She's a member of the Chartered Institute of Arbitrators and a founder and executive director of the ADR Center here in Uganda. She's also the vice chair of the Chartered Institute of Arbitrators Education and Training. She's a thought leader and a professional in multiple sectors. She's an academic, she's a project manager, ESG, PPP, ADR, management consulting. So she's a very well-rounded soul. She's also Moot director of the, let me not even try to pronounce this, ISAMEC arbitration moot, overseeing over 15 universities and mentoring young professionals. So you can hear ADR and the youth are very much part of her world. Then we've got Barbara Kiley. She's our first opposer. She's sitting right at my far left. She's a lawyer and advocate of the High Courts of Kenya. And she's actually also a very significant ADR leader. She contributed to drafting Kenya's ADR policy. She also contributed to the Nairobi Center for International Arbitration Rules and its operationalization. She's presently the Uganda country manager of the IDLO, where she leads initiatives to strengthen the rule of law, access to justice, and institutional capacity. She's also a legal and governance expert and an ADR specialist. Welcome, ladies. Last but not least, we've got Edith Twinamasiko. She actually taught me how to pronounce her name properly. She's our second opposer. She's also a member of the Chartered Institute of Arbitrators, and she's also the legal counsel at NSSF Uganda. I was saying to her that Kenya has just sold Kenya Pipeline to Uganda, so she's the right person to be talking to. She's the founder and executive director of the award-winning African Women in Arbitration, which advances women's participation in ADR. She's an advocate of both High Courts of Kenya and Uganda. And she was nominated in 2024 as the Young Arbitrator of the Year at the African Arbitrator Awards. So welcome this wonderful panel. Would you give them a round of applause, all women? Thank you. Before we start this, I just wanted to give you some quick facts, two quick facts, which were published by the London School of Economics in a paper called The Global Trends in Climate Change Litigation 2025. That snapshot was done by Joanna Setzer and Catherine Higham. And a couple of things that they have found, which I thought would be interesting for us as we start this debate. Number one, 25% cases of climate change cases filed in the global south, i.e. Africa, Latin America, the Caribbean, Asia, and the Pacific, involve companies as defendants. 70% involve governments as defendants. Fact number 2, or that they found, or finding number 2, was that in the majority of cases, plaintiffs seek legal avenues to hold government and corporations accountable for their contribution to climate change and inaction. There is a famous case that you may be aware of, 2024, where Senior Women for Climate Protection, which is a group of more than 2,000 women aged 64 and above in Switzerland, brought a case against the state on account of global warming, and the courts actually agreed with them. Why am I giving you these particular facts? Climate change disputes, where the conversation is around, is arbitration the space for it? Arbitration is usually contractual, but you can hear what sorts of cases are coming through. So, structure of our debate for this session, we will start with the proposers. We will start with Nanza, and then we will go to Eunice. And we will, it's not a debate where it's a fight, so we will let them each speak for about 5, maximum 10 minutes. Then we will move to the opposers. We will start with Barbara, and then we will go to Edith. And then we will have them rebut. That is where the fight will happen. Now, please pay attention to what the others are saying. That is where you need to be pushing back, if you need to push back or you need to clarify anything. I will then come back to you and see whether you've actually learned anything about climate change and arbitration, and we will make a final vote before we end this session. So, there we have it. We will start. Right? We are going to start with Nanza.
Good afternoon.
Take it away.
Welcome to this Oxford-style debate. There's something for you here. I am here to confirm and propose that arbitration is the most suitable form of dispute resolution for climate change. Thank you very much, Wanjiku, for the facts. And I like that you mentioned the statistics that are staggering from Africa, the Global South, Africa, Caribbean, and Latin America, where we in this house belong. But let me bring it home, then I will let you know why this is called Gumzo La ADR. In Uganda, we did file a case, probably the only known case in climate change regarding the Bududa landslides or mudslides. If you're familiar, it's a climate-related disaster that happens very frequently in the eastern part of the country. That was in the year 2020. As at December 2025, it was filed by Summer, William, and 47 others affected by the floods. This community just wants, they just want very few remedies like warning signals, resettlement options, and they're filing against the Attorney General. As at 2025 December last year, the court was yet to decide if there's indeed a case and whether it will proceed and be allowed to a full hearing. If the conversations that have happened, the gumzos that have happened from Monday, Tuesday, Wednesday, Thursday, where speaker after speaker have confirmed the backlog and the overload in the traditional court systems, have not convinced us that arbitration is the way to go, where you have lives at stake and important decisions to make that are time-bound, then this House will be convinced by the end of this debate that arbitration is our only safe way out of this crisis. Climate change is a crisis, and by the very definition, it says the disruption of climate and environmental systems. The problems of climate change are not ordinary. We have felt them. You cannot debate them away. You cannot politicize them away. And the solutions to climate change need to be yesterday. My first argument why arbitration is the first and most important arbitration mechanism that we should consider in as far as climate change is concerned is one. We have architecture that already exists. We do have from way back, from the Kyoto, the United Nations framework and conventions and charters, we have all these frameworks that have sat globally and have come up with ways to talk about how to mitigate climate change, where we've had stakeholders involved. The tapestry has been woven from the side of international law, climate law, human rights aspect, investment law. When we come to the investment side, we have bilateral treaties and all the fabric that we need to have arbitration just be taken up so that we get the gains of finality and enforcement as we know them without reinventing the wheel. Yes, they might argue that when we come to the investor side of things, the treaties under which these investors work, because we all know that at the international trade or international investment level, investors are looking to protect their profits, their investment, and their money. The treaties are old generation and old school, but there's been progress. We know that charters like the ECT, the Energy Charter Treaty, which deals with energy transition, has been very instrumental, intentional, and careful in dealing with these very issues so that in a progressive way, ESG is handled not as a matter of regulatory risk or reputational risk, where companies, which are mostly MDAs and the big companies that become defendants, as we have noted in the statistics, in these cases, are obliged by law. It's no longer wishy-washy if they should be compliant with ESG considerations where climate change falls. So we already have gained on the infrastructure and the architectural part of climate law, balancing the harmony with international investment law. Why should we throw out the baby with the bathwater? I strongly suggest to this House and those that are listening that you be persuaded that we maximize and consolidate the gains instead of moving 2 steps backwards. Speaking of which, the Gumzos have spoken over and over, from the SME panel that has just spoken, the international investor panel that was here earlier, and all the speakers before have emphasized the benefits of ADR, where we have enforceability, recognition of awards, and finality. If we go to the other options that we have as we resolve climate disputes, chances are that the issue of finality, as I have highlighted in the Bududa case, remains up to the system that does not have procedural flexibility. Again, I would like to remind this House that the issues of climate change are not a luxury. It's an issue affecting human livelihood. So we don't have the luxury to decide if finality is something we may or we may not consider as a critical path to resolving dispute. We cannot go the other continuum where we have mediation and conciliation, where parties just decide, well, we could talk about this, let's see where it goes. There's no time for emotions because decisions about climate change need to have been made yesterday. The other reason why I think arbitration is the best, and this is to bring to speed juxtaposed to litigation, there's always been this delicate dance between investor incentives, investor rewards, like damages when we go to litigation where they think it is obvious that it's easy for courts to determine based on climate science. Climate science serves both the litigation and the arbitration in equal measure. But arbitration takes it a step further, and this is why. Where you have general legal arguments in court leading to a resolution, actually leading to a decision, it's not even a resolution when it comes to courts. Like we have heard over and over, most courts dispute the dispute. ADR resolves, and there's a very big difference between settling a dispute and resolving a dispute. We don't need to go back to that. My point is, arbitration will give you the benefits of procedural flexibility, will give you the enforceability and finality, while at the same time giving you a cherry on top, which is what? You get to choose the expert. In arbitration, it is party autonomy where you get to decide an expert that is well-versed in this subject matter, in this case climate change, as opposed to getting to a generic practitioner where they still have to employ expert opinions, add in the inflexible court terms of strict evidence and timelines and all the things where you don't choose the timeline in which to conclude or decide on a matter. Arbitration and litigation will benefit from climate science in terms of quickly determining issues of liability, damages, contributory negligence, so that a resolution is reached, and then the environmental issues that are affecting humanity are addressed as immediately as necessary. My final one for now is about precedence. The fact that in arbitration we don't follow precedence, it means that we are not going to copy and paste solutions from anywhere. We will have bespoke solutions for our communities, for the issues at hand, without being bound by statute this, code this, as it is with the other methods. When we go to the other side, there's a continuum. Again, there is an issue of enforceability. So negotiation and mediation are not even in the room because they will give us non-binding decisions. Thank you very much. I give my colleague to proceed from there.
Go ahead, Eunice.
Madam Chair, moderator, thank you very much, colleagues and fellow dispute resolvers. Just to paint a picture of what climate change is, sometimes it's being confused as end times, you know. In Kenya, the past week we had devastating floods. You know, unfortunately we lost almost 50 Kenyans, at least that is what the report said. So climate change is pretty serious. And we have seen other effects of climate change. You know, you have scientists who are able to link things like famine, flash floods, and other kind of disasters, landslides, to climate change. So what really comes to your mind when you think about climate change? You think about a global issue. Those of you who have attended these climate negotiation meetings, I have attended COP15. You find the whole world is gathered there, okay? And the whole world is gathered there because climate change is a global issue. Global issues require global solutions, such as dispute resolution mechanisms that are able to cut across countries and boundaries. So that is arbitration. That's what arbitration offers. You will not get that effectively in any other dispute resolution mechanism. So first, that is one. Climate change is transnational and as a global issue because, you know, you could find a local Kenyan society going to court over activities on Lake Victoria, and yet it is an investor here in Uganda who is drilling near Lake Victoria that is causing it. So basically, given that solution, where do you take the parties? To court in Uganda? Whom do you enjoin in that matter? Arbitration offers neutrality in terms of a dispute panel that is untainted by factors that you'll find in most domestic institutions. And as we all know, most arguments against domestic courts are that they are very liable and prone and vulnerable. Why? Because they are vulnerable to things like political pressures and influence. So that is one. The other issue is that you find climate change disputes proper, not the ones we have seen in some of our cases. They are mainly dealing with the question of human rights, which is very important, and the issue of maybe environmental impact assessment. Climate change disputes proper should be able to find a company in Netherlands liable for having not stopped a certain amount of emissions, and that can only be done by help and use of scientists. Therefore, it is science and technical heavy. Now, what am I saying? Arbitration offers us what we can't get anywhere. It offers the opportunity for you as parties, and this goes hand in hand with party autonomy. We've said this is also a learning opportunity to pick a panel of persons that are well schooled and learned in a certain field, say climate change. People are now taking courses in climate change and climate-related and environmental-related knowledge. So you pick a panel of the experts you need. Also tied to that is the fact that you get flexibility that we seldom get in our courts, okay? When we have clause of pleadings, you know, some judges will not open for you your pleadings. But in arbitration, once we have decided, because climate can change and we may need to gather more evidence, we may need to go on a site visit or agree on specific experts to do a report. You get that flexibility and you are able to effectively determine your dispute. The other aspect of why we advocate for arbitration as the best method to resolve climate change disputes is that you get to understand what really are the nature of these disputes. For those of you who are working together with us, you understand that climate change related disputes can come in 4 categories: state versus state, investor-state disputes, you can get large corporations, and also public interest related disputes. Does anyone in the room know of any bilateral or multilateral treaty that has advocated for litigation, for example, as a method to resolve climate change disputes? By a show of hands. I don't think I need to say anything further. Thank you very much.
Thank you, Eunice. Well, you've heard the arguments for arbitration. We're going to hand it over now to Barbara. Oh, okay, we've changed rounds. Okay, you want to come talk from here? Come, you're welcome.
Thank you, moderator. I oppose the motion that climate change disputes are best resolved by arbitration. And I'll just maybe begin by saying climate disputes, they are not simple commercial agreements. They are public, they are political, they are scientific, they're environmental, and above all, they are generational in nature. So, and the more we study about climate disputes, how they are evolving globally, the more it becomes clear that arbitration is not structurally made to handle many of them. I'll give an example of the UN Framework Convention on Climate Change. Yes, it allows arbitration, but it does not define what climate disputes are appropriate for arbitration, and this has led states to avoid it, to avoid arbitration altogether. So, and then at the same time, climate cases are expanding into public law territory. And this territory involves human rights, national policy, state responsibility, vulnerable communities, and how climate impacts them. So these issues just demand transparency, accountability, among other reasons that we're going to tackle. So I'll handle 2 arguments, and then my colleague will add on it. So my first argument is climate disputes are increasingly public law disputes, which require transparency and not private processes like arbitration. And climate disputes, they involve public rights, yeah? Environmental protections, human rights, yeah? We're all aware. And in 2025, the Inter-American Court on Human Rights, in its advisory opinion, it held that states should progressively take coherent climate action to protect the ecosystem and prevent irreparable environmental damage. So this grounds the climate obligations in public human rights law, yeah, rather than the private arrangement that arbitration provides. So what does it show? It shows that climate disputes involve public interest, and they involve public accountability, and they involve, forums where the adjudication will involve communities, NGOs, and the affected people, yeah? So arbitration being confidential and party-controlled, it cannot deliver this. And my second argument, before my colleague comes in, is that arbitration lacks inclusivity. And those affected by the climate change cannot really participate in it. So arbitration is between parties. Climate disputes are not really bilateral, yeah? They include many parties, states, private companies, the indigenous people, the local communities, among others. So arbitration excludes these really affected groups, yeah, to participate. Yet, like I stated earlier, the Inter-American Court on Human Rights, it stressed that climate disputes must integrate indigenous knowledge and community participation. So arbitration is not built for community participation. So, but then if you look at the courts and maybe other public tribunals, they are. So I'll just hand over to my colleague to give the further arguments. Thank you.
Good afternoon. Good afternoon. Are we still awake? Are we still in this debate? How many have lived in Jinja or have been to Jinja severally, especially in the last, and this one is not for the Gen Zs, last 30, 40 years? Great. Do we recall how Bujagali Falls were? Do we remember? Are they the same right now? No? Can the communities around Jinja continue practicing the same fishing enterprises that they used to as they did before? Why? The dam, the hydropower. That's one example of an infrastructure project that, when it is undertaken, sometimes has devastating effects on the livelihoods, on the economics of the people who are living around the area, and also even the weather, climate change, sometimes, some of the effects of the projects that we do. Eunice has mentioned the death tolls in Kenya, and some of them, especially in Nairobi, were along the Mombasa-Nairobi highway, especially the expressway. This was after the construction of the Nairobi Expressway, because the drainage system was not updated to deal with the excess runoff of water from the expressway, causing floods, causing damage, causing a lot of devastation. You tell me, you're driving in your, is it called a Kawundo? The Harrier, yeah? It's called a Kawundo. You're driving your Kawundo somewhere on Jinja Road, the floods come, you're next to Forest Mall, or better yet, you're next to Garden City, the floods, your car is washed away, God forbid you also die. Or Nachivubo channel, we saw the damage that was caused there. An investor, local, with the government agreeing on investments that are ideally good for the community, but how do they end up? They end up with devastating damage that affects the people who were not part of the contract. Now, why am I mentioning all these things? It's because when we're talking of arbitration, we're looking at privity of contract, the parties to the contract. Are you a party to the contract when you have been just a normal Ugandan enjoying your way up and about Uganda, but you're affected by the investments? How do you take harm to court? Specifically, if you're talking about arbitration, which tribunal would you take harm to? Which tribunal would you take the construction firm that put up the hydro plant in Jinja? You tell me, which tribunal? They will ask you, how are you here? What brings you here? What right do you have to be here? But our courts, public interest litigation. And the costs, because that is what I want to focus on. For public interest litigation dispute, I'm glad SC Gimara is here because I know he's just done one with Sepil. How much did it cost you to file it? Do you remember? Above 3 million? 1 million? 2 million Uganda shillings. How much does it cost you to go before some of these tribunals? And the decision that you get, do you enforce it against the state? What does the state use to run its affairs? Taxes. Where are taxes from? Your pockets. So should you pay the government to participate in a forum that is supposed to protect your interest without your participation, with your money? It's your money. But are you consulted? No. Do you participate? No. So yes, the Bududa people unfortunately have taken years in court. And maybe court is not the solution either. And I think the essence of this debate is to look at when we are thinking of the disadvantages of arbitration, because we are anti-climate change disputes going before arbitration tribunals, it is to reflect on what could be the most adequate institution. The costs for appearing before the arbitral tribunals are high. The community in Bududa cannot afford it. They would have to dig into their pockets whilst surviving other landslides. Because we are in the season of landslides right now. Do they have the money to think about going before an arbitral tribunal? Or would they rather, they call the courts and the government to sit with them where they're most affected at locus to find a solution that is workable for all of them? And arbitration is definitely not the forum. What about enforceability of that particular decision? So when we mention that we will get damages against, for example, an investor who was not perhaps practical in the decision that they took or in the investment that they make, but when the damages are paid, do they get back to the Bududa person? No, they don't. They go to the state. The state will use it for its priorities. What are the state priorities right now? Making Uganda 10 times more economically viable. So we need to grow beyond just seeing a particular forum as the best forum. Yes, for certain climate-related disputes, you can go to the arbitral tribunals if you're talking about power purchase agreements, if you're talking about emission reductions, but those are obligations that are against the state. Where will the people be able to fund their participation in this? We've talked about experts. The costs of affording these experts, it is not something that is available to the local community. Now, you know, for me, particularly, I will focus on the local Mtuawansi because that is what is important to us. And it is important to also think about arbitrability of the disputes. Which type of dispute specifically should go before an arbitration tribunal? Not all of them, definitely. If we look at the Great Lakes region, and we look at how right now Ethiopia has concluded constructing its dam, what has that resulted in? Reduced water levels at the Lake Victoria, which means our fishing communities can no longer fish anymore. If Uganda was to go and sue Ethiopia for breaching the agreement of the Great Lakes, will the resulting decision benefit the communities around Lake Victoria? Will that decision also benefit, for example, because Lake Victoria is not just a Ugandan issue, it is an issue that also connects to River Nile. Lake Victoria is bordered by Kenya, Uganda, Tanzania. Tanzania takes the highest share, Uganda, then Kenya. River Nile cuts across over 11 countries. So these damages, would they be sufficient to pay for the communities that have been affected by this? Would arbitration truly be the appropriate forum for that? Are we going to discuss procedural fairness when you're looking at lives and discussing lives? Do the costs of our lives have a procedural definitive requirement on it? I don't think so. And I think that's why we should pause, reflect, and think again. Which forum would be most appropriate for climate change disputes? I do not know which forum that is, by the way, as I stand here. But I think we are beyond the question of looking at it as this is the forum, therefore we should be going to it. But we should be looking at what is the cost of climate change to our people. If the cost is our lives, then definitely it requires a forum where we can equally participate without an inhibition of cost. A forum where the decision can be enforced, not just by the courts, but even other administrative arms of the government, for example, the Ministry of Lands. It should also be a forum where the question of arbitrability or the question of interest would not be one that bogs you down with technicalities to be able to justify why you are before that forum. So no, we are not throwing out the baby with the bathwater. We are simply saying, as the midwives, that this baby's life is so important that we need to consider that perhaps the bathwater can be used for something else rather than being thrown out, that the umbilical cord can be repurposed for other issues. Why am I saying all this? And my time is up, so allow me to conclude. Because when we're looking at binding outcomes, especially those that would come against the state, Wanjiku told us the statistics. We know our success statistics before arbitration forums. We know the challenge that we are facing in trying to build capacity to be able to participate meaningfully in all these tribunals. What does that mean? It means that the system has tilted, unfortunately, against we as the Africans who bear the brunt of climate change. So definitely arbitration is not the right forum for us. Thank you very much.
Thank you very much, Barbara. If I could summarize it very quickly, what are we hearing? We're hearing, on the one side, expertise, yes, no, it's really, from what I heard, expertise is really like the big reason for proposing arbitration. We are hearing on the other side, and I think I alluded to this at the earlier stages, arbitration is a contract. There has to be one party consenting to be in an arbitration proceeding. In those sort of public affairs, where is that contract? Which is why we are seeing those statistics that show the bulk of climate change actions are communities taking on government or corporations where there isn't actually an arbitration agreement. So there is that. It's an issue. And I think, Barbara, you asked a very good ending question. This is not an absolute position. And maybe what I'd like to ask our panelists now is if you could possibly, if there's anything you want to say to rebut anything that was said, this is your opportunity. But if you could possibly focus on what is the solution. Because we can't just take two opposing positions, there must be a solution to this. What do you think it is? We start with you, Nansa. Mm-hmm. And I think for this session, sorry, Nansa, you're the only one who didn't get up here to speak. I will only allow Nansa up here. Everybody else, please speak from your seats because I need to control this properly. Thank you.
Thank you very much. And thank you for staying until this time because we have to land this ship. Somehow we can't leave this debate hanging. And thank you very much, opposers. The proverbial baby and bathwater scenario remains, but this is my take in way of rebuttal. Bududa has been tried and tested for litigation. 5 years down the road, we still don't know whether or not they even have a case or a chance in court, as previously submitted. But we do have a chance at arbitration with all the complications and cost and party autonomy and contractual necessities. The previous panel talked about innovative ways to maneuver, yet get the benefits of arbitration. My colleague Anne just talked about third-party funding. Imagine if we had a third-party funder who could support Williams, Summer, under 48. To resolve this through arbitration with expert knowledge, I think the proverbial baby bathwater situation will not happen. But back to your question, Wanjiku, about doomed if we do, doomed if we don't. Cases like Bududa are some, but not all. At the introduction of this debate, we made the intersectionality between investment law, arbitration law, international trade, human rights, an indisputable fact. Investors think about risk, and as we heard earlier this morning, investors put a price on risk. For them, risk is not qualitative, it is money. If we are investing money and expecting people to invest in our countries, as we've been promoting seats of arbitration and all those, we have to take the gains, as is the theme of this conference, sorry, the theme of the Women's Month, but also the gains, those who live in Uganda know what I'm talking about, and take the gains that we have done as previously submitted through the ICSID rules that have been amended to address the issues of transparency, to give investor confidence that there will be a delicate balance between state interests, but also reduce the level of entitlement so that public interest initiatives and public interest concerns will be balanced against the scale of investor stabilization clauses so that we can have harmony, but not throw away everything. So I conclude by saying that if we take the gains already made in the arbitration, investment law, human rights, and environmental law or climate law as it is, and juxtapose them to the others of the treaties that are now new generation, we will gain the benefits of not just one, but a universal standard, because climate change as it is not country specific. We are all suffering at the same time, and the problems are urgent. It's a humanity crisis that needs to have been solved yesterday. Thank you very much.
Thank you, Nansa. All right, it's rebuttal time. Go ahead.
Yes, I just wanted to add a few things. One, I have tried so hard to listen to the arguments of our colleagues. I am not sure I heard anything in terms of telling us why not arbitration. Why not arbitration? Because arbitration is the best forum to resolve climate change disputes, and you will not get a better one. I have checked in Uganda. You had 2 cases relating to climate change. One relates to Mbabazi, the Mbabazi case, which has been in court since 2012, and to date it has not been resolved. You see what we are talking about? Our colleague talked about why she's interested and passionate about communities, as I am also, and therefore it's important to have the communities have a forum to talk. And ladies and gentlemen, you know, climate change disputes and resolution is not a talk shop. You don't want to sit and talk and, you know, you have invested billions and trillions of dollars to mine or to drill or to check on some minerals. So you need and are focused on one, certainty in the dispute resolution mechanism. You're looking also at certainty in terms of rules and regulations. Where best other than arbitration? You will choose the rules you want to rely on. And in terms of transparency, I'm sure you all know that we now have in operation, I believe for over 10 years, the UNCITRAL, United Nations Commission on International Trade Law, rules on transparency in in arbitration, international commercial arbitration, particularly investor-state disputes. So you have the possibility of transparency, particularly where states are involved and investors. I have had the privilege to deal with a dispute between the government of Rwanda and an investor from from Uganda, and the investor from Rwanda actually won in that dispute, and it was enforced. That's the other point. They talked about enforcement. New York Convention is actually ratified almost internationally, universally. 170 countries have ratified it. You know what that means? When I get my arbitral award that has been determined by a panel that I chose myself, within a time limit that has been set by the rules, and not 2012 to now, how many years are those? Then I am able to take that award and have it enforced anywhere where the losing party has properties. In other words, arbitration offers a more appealing dispute resolution mechanism, even for communities. And there are various examples I don't want to get into, but there are various cases where communities have been awarded handsome amounts in compensation that have been arrived at by expert opinion, determination in the arbitral tribunals, and they live there happy. Because even though, and you know the question you asked, what do we do when there's a landslide? You move. That's the first thing you do, move away from where the problem is, go to higher ground, find your way, you know. After you move, then you think about how do we resolve this dispute? You know, and even for domestic dispute, it is still arbitration. Now you have ICAMEC. Make use of that. You'll even be protecting your judges, because a lot of our East African and other countries, we do not have specialized courts that have acquired special knowledge in climate change. So you'll be protecting your judges by having arbitrators from ICAMEC and also building that knowledge appointed. You know, courts can be corrupted. They are politically vulnerable, and that was alluded to. So I'd like to say, in support of this motion, that, ladies and gentlemen, no matter what you do, I want to persuade you that when the call is made for those in support of the motion is made, you all be persuaded that indeed you haven't had any other argument. We are certain. They are not clear. They were asking, we don't know, we are not sure. We are sure it is arbitration, and we hope you will support the motion.
Eunice.
Thank
you, Eunice. Well, you've heard it. Just move. Just move. Barbara, you look like you wanted to say something. If there's a mudslide, just move. Over to you.
Move to where? If allow me to give you a brief of Bududa. Bududa is a mountain. They're on the mountains, right? Mount Elgon. Am I correct? Right? The Ugandans are here. Am I correct?
Yes, it is.
So when they're moving, where did they move to? They were chased by the other communities. And where the government resettled them, do you know what happened? They didn't know how to survive. Why? They were used to the environment that they had grown up in along the slopes of Mount Elgon. So it's not an easy answer of saying move. Move to where? The people of Nyando are always being carried away by floods. And every year in Kenya, we complain, why haven't they moved? And they tell us every day, to where? This is where our burials are. This is where our burial grounds are. This is where our heritage is. So we cannot make this argument thinking about it simply in terms of collecting money. It's not a money question. It is not about getting refunded. And we know for a fact that the ISDS forums are not forums that are going to deal with my right to a clean environment. That is not what they will deal with. They will deal with whether or not there was a contract. In that contract, what were the rights? The most favorable nation rules will apply. There's a question of the exhaustion of local remedies will also apply. But they will not look at whether I can claim for my right to a clean environment, which is why the Swedish ladies had to go before the court, because there was no arbitration tribunal that could address their answer. It needed a cross-cultural, cross-country decision that is binding and enforceable against multiple countries. Where do you get that from a contract?
Thank you, Barbara.
Let me just
You've got something else to say, all right?
Let me just say this. The forum, I'm not saying go to court. And even court has recognized that because court has said we now have AJS, we now have ADR. So it is a question of management, the lawyers. And here I come against us as lawyers. When you have such a public interest case, why are you still in court 5 years later? When you have mechanisms that can help you to address that court. We should stop this attitude that if the court does not give me a date, we need to take action, be proactive in the management of disputes that are affecting a community. So it is not that I am saying that because the courts are what is available, they are the most appropriate forums. No, I've asked us, let us think about it. It could be what Professor Muigai said. Consider perhaps a regional court that is acceded to by all the countries in Africa, for example, as one of the mechanisms for operationalizing the CFTA. A court that when it's looking at trade and investment would also have the additional mandate to address climate change issues in an African manner, because that is a priority to us. We must recognize that the remedies provided in the arbitration tribunals are not remedies that are recognizant of the needs that we have as Africans, and most especially as women and girls. Thank you.
Thank you, Barbara. So there is a potential solution I think we've just had, possibly a regional, an African court that is specially trained and capable of handling these sorts of disputes, because it's not one or the other, there's benefits from both. Edith, what do you think?
So when we're preparing our argument, one wanted to oppose arbitration, but also not say we're going for the courts, because we also know there are disadvantages to that. So I'm for Barbara's argument, if we can find an avenue, yes, not arbitration and not courts, that will really resolve these disputes faster, and if it's less costly, So if it brings us to a regional court, why not? We just want to resolve these disputes as efficient and as fast as we can. I know Eunice is coming for me, but...
No, actually, we'll not allow any further debate on it because we want to hear from our audience, actually. Please get ready to vote on this. I hope now you've gotten a proper sense of what the issues are around climate change, arbitration versus litigation. So, I'd like to open it to the floor. Anybody with any comments, questions, anything that's burning? Yes, gentleman over there. You need a mic?
I do have one, and allow me 1 or 2 minutes to support the argument that actually climate change disputes are arbitrable. Those in opposition, I think, have taken a narrow perspective of arbitration to only inter-party, and have not considered that within the ambit of arbitration, we have investment arbitration, treaty-based arbitration. Now, when you talk about state-investor disputes, we have climate change, we have environmental disputes. All those are already arbitrable currently. And we've seen an increase in state counterclaims to hold investors to account on environmental issues, on renewable energy issues, as well as carbon credit aspects. So the debate is no longer whether they're arbitrable. They're already arbitrable under investor-state disputes. So when you talk about treaty investments, there are obligations by investors relating to environment, relating to regulations that touch actual climate change. So at the moment, even the argument of public policy, those are already arbitrated within the exit environment. So I would want to join the perspective of those who support the proposition that indeed climate change disputes are arbitrable. So the aspect of Bududa, I do not know who would be bringing that aspect, since we may not even have parties other than the act of court. But if it would have happened as a result of investor action, I believe under enabling treaty provisions, if any, would cover that. I submit.
Thank you very much. What's your name before you hand over the mic?
Patson Arinaitwe.
Patson. Thank you very much, Patson. There's a gentleman right at the back over there. Thanks. And please introduce yourself before you share your thoughts.
Yes, thank you. I'm Kalanzi Disan. I'm an associate with Abmac Associates. And I'll be on the side which says that most climate change disputes, by their very nature, are not arbitrable. Many of the points have been mentioned, but I would like to point out a very important point, which is that we are not only looking for money in such situations. You're looking for declarations, usually, of certain rights, that these rights exist. You may be looking for enforcement of some of these rights, which many of these arbitration tribunals, or where you go to for arbitration, where they may not be able to grant you these that you're looking for. Also, the fact that most of these things cross across countries. For example, something that has been done in Ethiopia can affect Sudan. Something that has been done in Uganda can affect Egypt because of what has been implemented by the government there or an investor who is there. I think the idea of having a regional court that deals with such disputes would be better than saying that we are going to arbitrate them. Yes, that is my submission, and I think I'm in support of the people that say that these are not arbitrable. Thank you.
Thank you very much. Anybody else? One last question or comment? Yes, go ahead.
Thank you. My name is Chinji Emmanuel Mackenzie.
Please speak up. I didn't hear anything of what you said.
My name is Chinji Emmanuel Mackenzie. I'm glad to have been here today and specifically to attend to this debate. I would like to start with a post that was put on the UN Environment Program handle. And to me, it took me by surprise that even up today, they're still asking us that how much do you know about climate change? From all our panelists, when you start listening deeply to what their arguments looked like, it's like they were only trying to transfer their conversation to a disaster or to a certain specific kind of calamity that occurs that is visible. But when we go back to the large ocean of climate change, I think it's just beyond calamity, it's beyond borders, it's beyond communities, it's beyond, I think it was one of the panelists, I didn't get the name, but she spoke something about climate change being a global circumstance that affects cross-border, that goes beyond borders of us talking in this room. And in the submissions made, I would love to associate myself with Miriam when she opposed the fact that ADR is the way to go when it comes into climate change challenges. I suggest that let the panelists, I think, take a deep breath and think about the width and the length of what climate change comes into play before they allocate the appropriate ADR mechanism to solve it. Because right now, we may not have the best scope of why we are arguing in what particular sector are we applying this mechanism. Because there are those that are just beyond just ADR, or like my brother said, arbitrable through the treaties that are recognized. But let us take a look of climate change being beyond what has come to us in surface of a treaty or pen and ink. Thank you.
Thank you. So we're importing some of it in essence. Thank you very much. We are coming to a close of this session, but before we do, I I understand we don't have a electronic voting mechanism, but I hope we've all learned something valuable about climate change disputes in ADR. So here is the vote. Question, those of you who support arbitration for climate change disputes, let's see your hands by a show of hands. I have 1, 2, 3, 4. I think we have 4, 5. Those are the ones for arbitration. And there's a couple more there, so 6. How about those? First, I'll do the middle ground. Those who believe that it would be best to have a regional type court for Africa to litigate, public litigation of climate change matters. How many? How many support the potential of a regional? Am I allowed to vote? Let's see it. Hands up. There is no winner or loser here. We just need to know whether we understood. And okay, you've changed your mind.
Even I support.
I'm sorry?
Even us we support. A regional
You're in search of thank you very much. The regional court, how many? You know, out of this, a decision could be made. I am for the regional court also. I am not for arbitration. Okay? Did I count them? There were 2 here, 3, 4. You put down your hands before I could count. 6, 7, 8, 9, 10, 11, 12. So we have double the number who are pro. Okay. How many are against? And just think, let's use the local courts. And so the regional court has it. I think, Gumzo, you've heard it. I hope this conversation will now move towards some action that sort of says, this is real. You're very right. We are importing it. Regulations are being passed. If you read Uganda's, Kenya's, Tanzania's climate change acts, very, very prescriptive sort of language, and you can find yourself afoul of it. Where do you go? So, thank you very much, ladies. I think you made this wonderfully interesting. Don't you think? Let's give them a hand clap. Awesome. And so that brings us to the end of this session. Ladies, it looks like you're not getting any gifts. I don't see them. Before the photo. Oh, there's a photograph. Yeah, here they go. Here are your participation certificates. Thank you very much.
Thank you, Njiko.
If you pick them up and then move over, where are we doing our photograph? Right here. Please hand them over. Please stand up and pick up each one of yours. So we will start with the farthest end with Barbara. Please come. Well done. You go, Barbara? Okay. Oh, Edith. Edith, please come. And then we have Then we've got Eunice Lumalas. And then we've got Nanza. Nanza, please come. And you know, we have I would like for us to give a very, very special thank you to Barbara. Do you know she wasn't part of this panel? She jumped in. And you can hear how well prepared she was and with great conviction. Let's give her a round of applause. Awesome. Oh, and I understand I have a certificate. Thank you very much. Thank you. All right. Where do we do this photograph? Okay. Please, let us stand up.
Thank you everyone for attending, and thank you to our panelists and our moderator. That brings us to the end of today's session and the end of domestic arbitration, domestic Gumzo. We will be back here tomorrow for international arbitration, and we look forward to seeing you. There is tea outside, so help yourselves, and thank you. See you tomorrow. While I still have you, just a quick update on tomorrow's program. We will be starting early in the morning with a panel on navigating emerging disputes in the energy sector. And then we will have a keynote address on navigating a unique African pathway in international arbitration. We will also have a panel on disputes to integration, AFCFTA disputes framework as a catalyst of resolving trade disputes and boosting intra-African trade. We will have another discussion on building connections, fostering African integration through commercial arbitration. And our last activity of the week that will bring it to a close will be the practical tips on hot topics in arbitration, in international arbitration, which will have different tables focusing on different topics. And we will also have looking into the future, effective institutional collaboration as a mechanism for enhancing the African arbitration opportunity, and a closing ceremony by the principal judge. So we look forward to seeing you tomorrow and to wrapping up Gumzo on a good note. Good evening to everyone.